All right, I am live and waiting for um, Barnes to come on board. This is a very, very last minute thing. So that is why I just put this out. And let me mute my other window. All right, how's everybody doing? I'm Eric Hunley. Today, Barnes will be covering the oral arguments. I don't know if I'll be here or not the whole time. This is a brand new channel, so I understand there's some confusion. This channel was previously another channel, but I have shifted all of my legal panels and my news items to laid back news, which is a more neutral location. And I will be bringing or providing the opportunity for people to put up a show on this channel as well. So let's say there's a debate, or let's say just coverage or breaking news, or somebody who's specialized. I want to provide a neutral location. It doesn't necessarily be my name for it. And the man of the hour is here. Robert, how are you doing?
Good.
Justice and the Associate
Let me get
Justices
this
of
switched
the
out
Supreme
right.
Court of the United States. Oh yay, oh yay, oh yay.
All right, let me
All
find a good view.
persons having business before the Honorable, the Supreme Court of the United States are admonished to draw near and give their attention, for the court is now sitting. God save the United States and this honorable court.
I'm going to shut up so we can hear the court.
Justice Sotomayor is participating remotely this morning. As in this application, Mr. Flowers from Ohio will also be participating remotely. And we will hear argument first this morning in application 21A-244, National Federation of Independent Business versus the Department of Labor and the consolidated case. Mr. Keller?
This is the
Mr. Chief
OSHA.
Justice, and may it please
Okay,
the court.
good.
OSHA's
There we go.
economy-wide one-size-fits-all
Try to do this.
mandate covering 84 million Americans is not a necessary, indispensable use of OSHA's extraordinary emergency power, which this court has recognized is narrowly circumscribed. Just 3 days ago, the U.S. Postal Service told OSHA that this ETS's requirements are so burdensome for employers that the federal government is now seeking an exemption from its own mandate for the Postal Service. That's because OSHA's economy-wide mandate would cause permanent worker displacement rippling through our national economy, which is already experiencing labor shortages and fragile supply lines. OSHA has never before mandated vaccines or widespread testing, much less across all industries. In fact, the June healthcare COVID ETS and the 1991 bloodborne pathogen rule both rejected vaccine mandates and widespread testing, and those were even just for targeting healthcare workers. And here, OSHA's vaccine and testing mandate treats virtually all industries, workplaces, and workers the same. But even Congress's rescue plan identified high-risk workplaces, and OSHA itself here recited state data confirming that certain industries like healthcare and correction facilities are higher risk. Our nation's businesses have distributed and administered hundreds of millions of COVID vaccines to Americans. Businesses have encouraged and incentivized their employees to get vaccines, but a single federal agency tasked with occupational standards cannot commandeer businesses economy-wide into becoming de facto public health agencies. So this court should immediately stay OSHA's unprecedented ETS before Monday when OSHA begins enforcement. I welcome the court's question.
Mr. Keller, how are we to decide
That's
when
Justice Thomas.
an emergency temporary standard or emergency temporary standards are necessary? What factors do you think we should use?
Justice Thomas, I think the first factor that you would have to look at
Thomas has been asking a lot more questions.
is this an
over the last year.
indispensable or
Yeah.
essential measure? And that
Ever since
necessarily
Scalia died,
would
he
require
kinda
looking at what
came
are the
into us.
alternatives available. You'd have to also look at necessary to what end, and it's to abate a grave danger, and it's for an emergency. It's in a temporary setting. So the factors you'd want to consider are what are the risks, and not only what are the risks for any isolated situation, but compared to an everyday risk. Here, when OSHA itself has never mandated vaccines or widespread testing before, That itself, even in its 10 prior ETSs, which courts blocked almost all of the challenges to these prior ETSs, all of those are factors that would absolutely determine the scope of what OSHA could do here. In fact, in the June ETS, what OSHA said was, quote, OSHA recognizes that many states have taken action to protect employees with mandatory requirements that may not be appropriate for an ETS on a national level.
That was one of the parties.
When in McCulloch versus Maryland, Chief Justice Marshall, in looking at necessary and proper, saw necessary as more expansive than that, as certainly modified by proper or in the context of proper. So it just suggests that necessary can be really necessary or not necessarily really necessary. And I just think that, you need more than to say, oh, a lot of bad things could happen to interpret what that means. Is it restrictive? Is it very firm? Is it super necessary? And if it is, why?
Justice Thomas, the reason why it would be something approaching the indispensable or essential definition of necessary here is there's a very key intra-statutory textual clue. The emergency power must be necessary. The regular power that OSHA wields has to be reasonably necessary or appropriate.
So when do we determine that? Suppose you argue also, this is the vaccine's been around quite some time. COVID has been around even longer. So the government could have had a notice and comment. So if it's susceptible to notice and comment, then how do you analyze it in that context? You can't just say, well, it's emergency, therefore it has to be absolutely necessary. It would seem that would undermine your definition or your notion of necessary.
Well, I think Judge Larson, before the Sixth Circuit, was absolutely correct in saying that just because something's temporary doesn't mean that there could somehow be more power. And what this court has said is this emergency power is narrowly circumscribed. And regardless of wherever the line would be drawn, I think this ETS is far past it. And I think the federal government has some serious line drawing problems of its own. I believe OSHA, and under the theory that's been advanced, could have shut down and had a national work lockdown at the beginning of the pandemic. I would submit that this court in Industrial Union saying that OSHA had no clear mandate in the act to have that wide of power over the American industry is also a factor that would go into this court construing what necessary means.
So the fact that it is that it's emergency sort of ups the ante, that necessary has to be more restrictive.
Yes, because of plain text, the comparison within the OSHA Act, also statutory context.
I guess, Mr. Keller, I don't understand the point. Whatever necessary means, whether it's necessary and proper or whether it's something more than that, why isn't this necessary to abate a grave risk? This is a pandemic in which nearly 1 million people have died. It is by far the greatest public health danger that this country has faced in the last century. More and more people are dying every day.
You think 6'3", like the Super Chat asked?
Every day. I don't mean to be dramatic here. I'm just sort of stating facts.
We're waiting to hear
this is
from
the
Robert
policy
Kavanaugh,
that is most geared to stopping all this. There's
your audio's weird. Are you on your iPhone or?
That will perform that function
on a laptop?
Oh, okay. Yeah, I don't know. It's breaking in and out. Oh well.
Maybe the internet.
Themselves.
Yeah.
So, whatever necessary means, whatever grave means, why isn't this necessary and grave?
Because, Justice Kagan, the standard for what would be necessary for this extraordinary use of emergency power is not what is the best way of accomplishing.
It's an extraordinary use of emergency power occurring in an extraordinary circumstance. A circumstance that this country has never faced before.
We've faced worse.
What OSHA needed to do here, though, and we do not contest that COVID is a grave danger, but when a power for it to be necessary, for instance, the Third Circuit said in wielding what is supposed to be a delicately exercised extraordinary power, the agency has to consider and explain alternatives. The agency here complained that its non-mandatory guidance wasn't being followed. And then instead of saying that maybe some of those guidances could have been made mandatory, it jumped immediately to a vaccine or testing mandate. Moreover, OSHA typically...
Mr. Keller, I guess I just don't see this as a situation, a typical arbitrary, capricious situation where we say, oh, you didn't consider an alternative carefully enough. We all know what the best policy is. I mean, by this point, 2 years later,
No, it's an
we know that
atypical
the best way
arbitrary.
to prevent spread is for people to get vaccinated, and to prevent dangerous
Look at
illness
that.
and death.
This is what
is
these
for
liberal
people to
judges
get
really believe.
vaccinated.
Everybody knows
By
that the
far
vaccine
best.
is absolutely the only
Second
solution.
Consensus.
is to wear
General
masks.
consensus.
So this
It's
is
utter
a
hogwash.
policy that basically
And that's
says
why attacking
we
the
are still
emergency issue, I think,
confronting
is something I hope they do a little
thousands of
more of.
people dying
Because it was the name of
every time we
emergency
look
that we got
around.
forced attention
And
can
so we're
for
going to put into
sterilization.
place the policy that we know works best,
gotta do
which
these
is to
things.
strongly incentivize vaccination and to insist that
There is no
unvaccinated
video,
people will
folks. The
wear
Supreme Court
masks
does not provide
and
that.
test.
Yep.
I mean, that's just like, why isn't that necessary? What else should be done? It's obviously the policy that's geared to preventing most sickness and death, and the agency has done everything but stand on its head to show quite clearly that no other policy
It produced zero
will
evidence.
prevent sickness
Zero.
and death to anywhere
Why should they?
like
It's
the
common
degree
knowledge.
this one will.
Exactly.
Justice Kagan, first of all, states could have policies like this. Private businesses could have policies like this. And even OSHA in its June healthcare COVID ETS, and that was only for healthcare workers, did not mandate vaccines. Instead, what it did there, similarly to how OSHA proceeds in many contexts, is it says, employers, give us a plan, and then if there are heightened needs in particular workplaces, then additional measures can be put into place. But this is covering economy-wide, all industries,
Well,
84
that's
million
One of
Americans.
that's one of your main objections, that this is not a workplace issue. It's a out in the world issue. Is that right?
That's right,
Robert
Mr. Chief
did it.
Justice.
Well, but how focused on the workplace does something have to
Maybe.
be before you will say that OSHA can regulate it? I think, for example, of an assembly line. Workers sitting next to each other for a significant length of time, working together in close contact. That presents a different kind of risk than is typical in the outside world. So could OSHA say that for businesses with assembly lines, the workers must be vaccinated?
No, not vaccinated. OSHA, though, could potentially, going by industry or workplace by workplace, have measures such as what some of their guidance have suggested, like, potentially barriers. But I think all of this would be...
Well, but those are sort of, as Justice Kagan has been discussing, those are sort of, not as good. And why wouldn't OSHA have the authority to
He's
do
wavering.
the
Yeah.
best
Loves
approach
institutions,
possible,
doesn't he?
to address what I guess you agree is a special workplace problem?
Well, Mr. Chief Justice, I don't think the standard here can be the best, because if it was the best, then that would mean that OSHA could ban all people from coming into the workplace. I think that is a power that Congress, when it
Well,
created
so the agency is acting, less aggressively than it might otherwise do, but in an effective way to address the problem.
But as soon as we get to the point where we're talking about a less aggressive way, there are other alternatives. There could have been plans. There could have been the non-mandatory guidance that was then put into place. Jumping to a vaccine or testing mandate when OSHA has never exercised that
Well,
power.
there is some pressing urgency to addressing the problem, and having them sit down and say, okay, what else could we do? We have to have notice and comment, which I guess, are you insisting that be part of the process?
In this situation, yes. I mean, you have the Postal Service and Amtrak saying many employees will quit. Here, there are
Well,
reports.
just
and we
because the
have-
post office can't do it efficiently doesn't mean that
You
private
can't do
industry
anything
can't.
efficiently.
But I think what this shows is workplaces are different. And instead of doing an economy-wide vaccine or testing mandate for all purposes, OSHA needed to at least consider, as it identified, there are certain instances where healthcare workers and otherwise in those industries where there's a heightened risk, that's where there's a workplace occupational.
I want to ask a provisional question. Are you still really asking this court now, today? I mean, I assume you have good arguments in your brief, and so does the government. So I'll assume for the sake of argument that they're both fairly good arguments, okay?
Thank you.
Right. Now, that's an assumption. Right. But
Brian, by the way.
Okay.
Take that assumption. Are you still asking us to issue a stay and stop this from taking effect? like issue a stay today or tomorrow or Sunday or Monday or Tuesday? I mean, the reason I ask that is there's several elements. We have some discretion there. And you know it was brought up. I mean, there are 750,000 new cases yesterday. New cases, nearly 750,000, 700 and some odd thousand, okay? That's 10 times as many as when OSHA put this rule in. The hospitals are yesterday, full, almost to the point of the maximum they've ever been.
While people are vaccinated.
Disease.
Yeah.
Okay. And you heard references, studies. I mean, they vary, but some of them say that the hospitalization is 90% or maybe 60% or maybe 80%, but a big percent filled up yesterday or the day before with people who were not vaccinated. Okay? So,
He's assuming things that
that's
are
what
just
we're
not
talking about
evident.
now. And
Yeah,
think of
I
the
mean,
stay
it's-
requirements.
He admitted
It's
himself
both the
that
balance
with
of
different
harms, there's
studies.
also
different
public
level.
interest.
Oh, wait.
Can you ask
same
us, is that
argument
what
that
you're doing
allowed
now to
court
say it's in the
defense.
public interest
Oh,
in
we
this
got a war going
situation
on. We
to
can't be
stop this
messing around with civil
vaccination
liberties in
rule
the middle of a
with
war.
nearly 1 million
Hey,
people?
look,
Let me
that's
not
what I would
exaggerate.
go back
Nearly 750,000 people.
Well, that's how every dictatorship
New
starts. It's
cases
not with
every day.
peace
I
and
mean,
love.
to me, I would find that unbelievable.
Justice Breyer, we are asking for a stay before enforcement takes effect Monday. And the reason for that is this is an unprecedented agency action.
Yeah, I know you have all good arguments that it isn't good. They have arguments that it is good. Okay, I'm asking you a different question. And the question is, how can it conceivably be in the public interest with 750,000 people yesterday, goodness knows how many today? I don't want to repeat myself, but you have the hospitalization figures growing by factors of 10 times what it was. You have hospitalization at the record, near the record. You understand the thing as well as so I repeat my question. To me, it's unbelievable, but I want to hear what you say. How can it be in the public interest, which is a requirement? How can it be a balance of harms in this case? Assuming the arguments aren't off the wall on the government side, and believe me, they're not. Okay, that's what I want to hear the answer to.
Justice Breyer, states can act, private businesses have acted on historic levels. This is going to cause a massive economic shift in the country. Billions upon billions of non-recoverable costs. Testing also is not frequently available. This is in our appendix at page 374. Among those employers who have attempted to do so, only 28% are able to find adequate providers to ensure that weekly testing is available for the employees. If Congress intended to give an occupational health agency the power to mandate vaccines across the country, it needed to do so clearly. States can do it, businesses have done it and are able to do it. The question is not what is this country going to do about COVID, it's who gets to decide that.
Well, Mr. Keller, maybe it's point, we can go with justice by justice. Justice Thomas, anything further? Justice Gorsuch?
I do have a couple of questions, Mr. Keller. First, the government says that the major questions
Gorsuch?
doctrine and federalism canon, for example, don't apply to this court's consideration of this case or any other unless the statute before us is first found to be ambiguous. What's your understanding?
Well, 2 points. If you need to even reach the question of whether there's ambiguity, and we think the term necessary is clear in context, it has to mean indispensable or essential, that would be a term where potentially the government in their interpretation would reach ambiguity. But regardless, the major questions doctrine is also in service of avoiding non-delegation concerns. And the non-delegation concerns that this court recognized in Industrial Union and citing
I'm sorry to interrupt you, but that wasn't quite my question. I apologize if I didn't make it clear enough. But the government says that we only consult those doctrines, the federalism canon, the major questions doctrine. I think the court understands what they are, but only consults them after finding a statutory ambiguity. Do you disagree?
I disagree in that the major questions doctrine is also a doctrine that would avoid non-delegation concerns. So even if there were a clear statutory term, non-delegation concerns in how to interpret that statute would factor in. Regardless, I think the term necessary here there's plenty of room to implement the major questions doctrine there, in addition to all of the workplace tethered languages in the plain text and statutory context.
And then secondly, I would like to understand your argument and your colleague's argument from Ohio, I believe it is, why the court should enter a stay immediately. You've asked for immediate relief. Why should the court grant immediate relief?
The short version is, as soon as businesses have to put out their plans and this takes effect, workers will quit. That itself will be a permanent worker displacement that will ripple through the national economy. So we can talk about the billions in non-recoverable costs that the government even concedes, and we can talk about the lost profits and lost goodwill and lost business reputation, and we can talk about the businesses that are going to be put out of business. Our appendix at pages 375 to 80 quotes many businesses saying this would be catastrophic. It would bankrupt our company. It would be the most devastating event our company has ever experienced. That's why we're here. We're asking for an extraordinary stay. We understand the gravity of the situation, but in balancing the sheer size and scope of this emergency power that is supposed to be exercised delicately, and the national economic implications of this when states and businesses can and have acted, we are entitled to a stay in this posture.
Justice Alito, sorry to run out of order.
No, fine. Mr. Keller, I just want to make sure I understand what we should focus on here. Is the question whether this ETS is necessary to protect the health of the general public, or is it whether it is necessary to protect just employees, and not even all employees, but only unvaccinated employees, people who have chosen independently not to be vaccinated and do not want to be vaccinated? Is that the proper focus?
Correct, the latter, Justice Alito. As OSHA has said, the grave danger here is to the unvaccinated worker who's exposed to COVID.
Thank you.
Justice Sotomayor.
I wonder if she's having a boomer moment.
Maybe.
She's appearing remotely.
Uh-oh. And meanwhile, the staff is going and scrambling around. So what do you think so far? Well, we're waiting for...
So as expected, I mean, Alito and Gorsuch and Thomas, I think, are going to say that the stay should be immediately granted. Roberts is on the fence like normal. And Breyer and presumably Sotomayor and Kagan are for justifying this because, the ends justify the means. I mean, that's basic.
Justice Sotomayor. The necessary analysis does have to account for alternatives.
I guess
we're not
sound.
asking anything close to a least restrictive means analysis. What we're saying is the agency...
No.
That's probably Sotomayor interrupting, and because she's doing it remotely, is probably not being clearly broadcast.
Okay. Well, makes for an entertaining speculation.
Yeah.
I'll say that she said, no, I'm just kidding.
I think it's safe to say that she's asking a question that says the ends justify the means, don't they? We're in the middle of a pandemic. Let's do what we've always done in emergencies as Supreme Courts in the United States, which is cower and act like cowards and not enforce civil rights and civil liberties or constitutional government. Right. I would be more aggressive in all this, but that's just my own approach. It's because what people are hearing is how much law is being asked here. Not a lot of law, is it? Particularly from a lot of the liberal justices. It's a lot of politics that they're asking.
Good point. Somebody brought that up in the chat too, that they sound like people. Sounds like me asking questions, really.
Yeah, and it reveals what really is going on. That this isn't about the law. This is about politics.
Man, what your Black Pill Barnes? It's been that way for a while, though.
Yeah, it has been, and that's where you have to go to the politics. You have to recognize that, and you have to remind them that when they've made decisions in the name of emergencies or exigencies or deferring to public health authorities or others, they've made morally horrendous decisions that have long led the court to. So the most infamous court decisions, the two most infamous, Buck and Korematsu, were done on these kind of grounds, either deference to public health authorities and self-righteous about it. Everybody knew. I mean, like there when Justice Breyer asked that question, my response was, yeah, Judge, everybody also knew, Justice, that forced sterilizations were a good thing. That certain poor people shouldn't be allowed to have more kids. Are you for that? Because that's the last time this court decided it was going to implement public health policy or just green light and defer to emergencies, we ended up with horrendous outcomes.
If you accept the agency's facts, there are now, as Your Honor just mentioned, CDC guidance contradicting foundational assumptions of this ETS. That's in our reply brief at page 7, and Your Honor just mentioned that. But regardless, even OSHA has said that 1 to 3% of employees will quit. That is significant. Our
That's why he's hammering the quit.
Appendix 308, 316.
Post office
Counsel, yes, that may be true.
Oh, there
but
she is.
We are now having deaths at an unprecedented amount. Catching COVID keeps people out of the workplace for extraordinary periods of time. And
2 weeks versus
there
life?
have been proof in
Or
certain
5 days now?
industries like the medical industry that when vaccines are mandated, and there's no mandate here for a vaccine. There is a masking mandate, no different than there
The lawyer
is
kind of made that point. He said the
when
question
we
is
tell
who decides.
people that if there are sparks flying in the workplace where workers have to wear a mask. So that's no different in my mind than this.
She's a small mind.
This is not a vaccine mandate. There are costs and deaths and other things countervailing to the fact that there might be 1 to 3% of workers who leave.
Well, and here, vaccines have been made available. I also think there's a textual clue within the OSHA Act, 29 USC 655.
You forget that there are certain states now that are stopping employers from requiring vaccines. There are certain states stopping employers from requiring masks. Why shouldn't the federal government, which it has already decided in OSHA, Congress has decided to give OSHA the power to regulate workplace safety, have a national rule that will protect workers?
Congress would have to clearly state in a statute if it wanted to give an occupational health agency the power to require employees to get certain medical treatment. It's one thing to say.
There's no requirement here. It's not a vaccine mandate. It's something totally different. And I don't know how much clearer than 651 Congress could have been. It charges OSHA with developing innovative methods, techniques, and approaches to dealing with occupational safety and health issues. I don't know how much clearer you can be if you're Congress.
A lot more
tell
clear.
an agency in an
Really a
emergency,
ludicrous argument.
do what's necessary.
Well, it's lazy too. She said it's a branch of government.
Congress
It's like they want to
can
promote OSHA as if they're Congress or another
Congress
branch.
was going to give an occupational health agency this type of power to essentially regulate directly the employee rather than telling employers these are the types of things that you would want to do within your workplace. It would have had to provide that clearly.
So what's the difference between this and telling employers where sparks are flying in the workplace, your workers have to wear a mask?
When sparks are flying in the workplace, that's presumably because there's a machine that's unique to that workplace. That is the...
Why is the human being not like a machine if it's
we're a machine.
spewing a virus,
machine now.
bloodborne
Well, now we know where it
viruses?
is.
Are you questioning
we know.
Congress's power or desire that OSHA do this? It already in 1991 told OSHA to issue regulations with respect to Hep C and B.
Justice Sotomayor, I think that exactly proves our point that Congress knows how to enact a statute when it wants to give OSHA.
It didn't enact a statute. OSHA proposed regulations. It didn't act fast enough, and Congress told it to act faster. So it wasn't Congress who proposed it. It wasn't Congress who devised it. Congress gave OSHA the responsibility to do these things, and Congress was saying, get to it.
And what Congress said in there was not, you now have statutory authority to regulate all communicable diseases. It was bloodborne pathogens, and even that rule did not mandate vaccines or widespread testing.
Justice Kagan?
Part of your argument I want to come back to, because your very last sentence you said, the question is, who decides? And I think that that's right. I think that that is the question. Respectfully, I think it has a different answer than the one that you give. So I'll just sort of put a different version of it to you, which is, I'm sure you're right that there are all kinds of public health and economic trade-offs that have to be made in a policy like this. All kinds of judgments on the public health side, on the economic side, how those two things ought to be balanced against each other. So who decides? Should it be the agency full of expert policymakers and completely politically accountable through the president. This is not the kind of policy in which there's no political accountability. If people like this policy, they'll go to the polls and vote it that way. If people don't like it, they'll vote that way. This is a politically accountable policy. It also has the virtue of expertise. So on the one hand, the agency with their political leadership can decide, or on the other hand, courts can decide. Courts are not politically accountable. Courts have not been elected. Courts have no epidemiological expertise. Why in the world would courts decide
now
this
she wants to
question?
step back from her power.
Yeah.
Congress and states and governors wielding emergency power are the ones that have the power, and we acknowledge that, over vaccines. The idea that OSHA would be the agency in the federal government that's not even under the Department of Health and Human Services, that does not have expertise over communicable diseases like the FDA or CDC maybe, that would just be a very odd place for Congress to lodge such a sweeping power over the American people.
Well, OSHA has a lot of expertise about workforces and about the dangers that workforces can confront individual employees with. And I'm sure OSHA also talked to other agencies within the federal government to consider public health issues and brought that knowledge to bear as well with its knowledge of how workplaces function. And again, came out with a well-supported policy
No, it wasn't.
that
has
has
very little
political
support.
leadership behind it and all the political accountability
Oh,
that
the
Only
goes
the
with
Biden
it.
administration.
And
It
why
didn't have
is
Congress
it that
at
courts
all.
would displace that judgment and say it is up
Because
to
as she's
us
talking about, I'm sure all
to
the press is
decide
behind it.
about vaccination policy in the employment settings of this country?
Well, first of all, what OSHA did here was not an industry by industry analysis. I mean, the line it drew, for instance, with the 100 more employee lines, they said they were doing that because they thought these larger companies were the ones that had the administrative capacity to do it. It wasn't because they were denser working environments. You could have a company with 100 employees and every single person is working somewhere else. Even the narrow exception that they have, right, that even they say that 9% of landscapers and 5% of highway workers are the only ones that would qualify for their exclusively working outside exemption. So even occupations in which you would think someone is almost exclusively working outside, they are still covered by this ETS. It's those types of internally inconsistent positions that aren't taking account of the full problem that could have been explained and should have been explained.
Thank you, Mr. Keller.
Justice Kavanaugh?
I want to follow up on Justice Kagan's who decides question, because I do think that gets to the heart of this. You're relying on the major questions canon in saying that when an agency wants to issue a major rule that resolves a major question, it can't rely on statutory language that is cryptic, vague, oblique, ambiguous. But the critique of that canon and the difficulty in applying it is figuring out when something is major enough. We've applied it 5 or 6 times in the last 40 years, and you know the cases, and they're important. We'll talk about them, I'm sure, as the argument goes on. But what should we look at to say this one is the kind of rule that rises to the level of the benzene rule or the tobacco rule that we found to be major? What should we look at?
So Alabama Realtors just said the sheer size and scope. Size would account for the overall economic impact. This covers 1.8 million establishments. The number of people affected would be another factor. This covers 84 million, or 2/3 of the private workforce. The amount of money, King versus Burwell said billions in costs, and here we have that even conceded by OSHA.
He was ready to answer this question.
All of the 10
The
prior
best answer of
ETSs
the whole
OSHA has
argument
done,
so far.
none of them have mandated vaccines. None of them have mandated widespread testing. Only one in June even dealt with COVID. The rest were all workplace toxins, and most of those challenges were most of those challenges were vindicated by the courts. And so the scope of what the agency has done before, in addition to the widespread effects, those would be the factors that you'd analyze. Also, is this a profound and earnest debate over a question of vast political and economic significance? at this point, believe that the federal government is contesting that this absolutely satisfies that.
And one follow-up question, suppose it is major enough, so accept that position for the sake of this question. Suppose the statutory language is general, broad, but doesn't speak specifically to the issue in question, but it is general and broad language. How do we sort out, so you don't necessarily say the language is ambiguous, but it also doesn't speak specifically to the issue. How would you suggest we sort out that kind of question? I realize you're going to say this language is different, but how would you sort out that kind of question?
You look at the plain text from Brown and Williamson. We know you'd also look at the statutory context. And I also think the statutory context here is incredibly important. When you have the distinction between the emergency power and the regular power, this is the dialogue earlier with Justice Thomas about necessary versus reasonably necessary or appropriate. All of those textual clues, where powers have been lodged within the federal government, the fact that this isn't within the Department of Labor rather than Department of Human and Health and Human Services. Also, King versus Burwell too on, is this the agency that has expertise over communicable diseases? No, it's not.
Do you think the agency could do this under its general power then?
No, I do not think that the agency could do an economy-wide vaccine or testing mandate across the entire economy. It has never done that even through its irregular power. It didn't do that in June in an ETS targeting healthcare workers, arguably the most heightened high-risk workplace.
Thank you.
Justice Barrett?
Mr. Keller, I want to return to the discussion you were having with both the Chief Justice and Justice Kagan earlier about whether the vaccine or test requirement is necessary to address a grave danger in the workplace. I think you would be hard-pressed to contest the Chief's point that there are some workplaces in which the danger to employees is different than that they face out in the world, a meatpacking plant or a healthcare, the dentist. And I think what you're saying, I think this is what you're saying, and I want to be sure that I understand it, that I'm correct. I think what you're saying is that even if there are some industries or some people who would face a great risk, and this might be necessary to address that risk. So in other words, if OSHA had adopted a more targeted rule, you might not be contesting that, or you would not be contesting that the problem here is its scope and that there's no differentiation between the risk faced by unvaccinated 22-year-olds and unvaccinated 60-year-olds.
Compromise
Industries, you were just
Barrett's
talking
going to
about
vote to strike.
landscapers
Barrett
and
ain't
people
Kavanaugh.
primarily outdoors. Those
She's going to
are,
use the two
workers
broad
who work
angles to
in an
cover her butt.
inside environment all day long. So is that the distinction that you're making? Like, they're not disputing what Justice Kagan said, that, this is a great
Sidney Poitier just died.
and that in some circumstances this rule might be necessary.
Sidney Poitier just died.
But just the scope of it makes it different.
That's right,
Great
Justice Barrett, but
Yeah,
just
yeah.
Met him
wanna be
years
very
ago
clear
in Santa
about this.
Monica.
Wherever
Legend.
that line
Legend
is,
for sure.
this ETS is so far beyond that line. Congress identified and even OSHA identified, for instance, certain healthcare scenarios. For instance, if you're treating COVID patients or you're a scientist in a laboratory handling COVID samples and researching them, of course, that's going to be a very different case. But here, what OSHA did was economy-wide. It said,
well, I understand that. And you're saying that that's the problem. You're not contesting that if we were talking about healthcare workers or a meatpacking plant, you're not contesting
she still
that
wants to
OSHA
say
could rely
vaccine
on
mandate.
its emergency power.
She just
She's
wants
giving him a
targeted
little
requirement
save, a little
mandate.
wiggle room. Like, I'll give
that's
you
right, I
this,
still want to
but
know what their
you get it.
explanation was and all the substantial evidence. But yeah, of course, that's a very different case. And I know that's always not a satisfactory answer. But here, this ETS is so far beyond healthcare workers and what Congress identified.
He
in the
doesn't want to
rescue plan as
concede
truly high risk.
that any vaccine
Right.
mandate is okay.
So you're
But he's
saying that
dodging
when we
it.
take the definition of necessary, particularly when contrasted with reasonably necessary in the general grant of authority, that it means something more, and that when we're looking at grave danger, there had to be a more targeted industry by industry analysis?
Yes.
Wow.
Okay.
So it looks like I'm
And
right
follow-up,
about
would
Barrett.
you be
Barrett's
here
going to
making the
strike it
same
down.
arguments if this were just a masking and testing requirement and not the vaccine portion of it?
Yes, I think that mandatory testing is still a mandatory medical procedure. OSHA has never, even in a regular rule, done a blanket widespread testing regime over 84 million Americans.
What if it was just masking?
I don't think
By the
OSHA
way,
has the ability to
Yeah,
set by
Lagoa on the
emergency
11th
rule
Circuit has weighed
nationwide
in on
COVID
this and said
policy.
there's no
The
basis
more that
for
we
it.
back out of this and the more we
So
say, well, if it's
Trump
not an
had put her on the
emergency
bench.
rule or if it's
There'd be no
targeted to
question
a
where it would
particular
go.
workplace,
Yeah,
I
no
think there can
surprise
be
there.
debates about that. But as long as they're trying to set a blanket-wide, economy-wide policy by an emergency rule, OSHA does not have that power.
Thank you.
Very promising.
Thank you,
Very
counsel.
promising. Barrett and Kavanaugh are going to join the
Mr.
other
Flowers,
two.
I don't
The only
quite know where
question
to
is,
look,
they
but
grant
are
the
you
stay or
still
they
on the
wait
line?
2 months to call it illegal.
Mr. Chief Justice.
I can see
you. You may
Roberts going
proceed.
the other way.
Yeah,
Mr. Chief
but
Justice,
he doesn't.
may it please the
He'll want to
court.
write the
OSHA
opinion,
typically identifies a
so he'll
workplace
join him
danger
if
and then regulates it. But
he's
here,
lost.
the president
Mhm.
decided to regulate
Then he can be
danger
important
and then
still.
told OSHA to find a work-related basis for
And he'll
doing so,
try to limit the scope of
which
the order.
resulted in the vaccine mandate, a blunderbuss rule nationwide in scope that
Good
requires
choice,
the same
blunderbuss.
thing of all covered
Good
employees.
Yeah,
wording.
I would say great
regardless of
word,
the
great
other
word.
steps they've taken to protect employees, regardless of the nature of their workplaces, regardless of their employees' risk factors, and regardless of local conditions, state and local officials are far better positioned to understand and accommodate. So sweeping a rule is not necessary to protect employees from a grave danger as the emergency provision requires. And I want to be clear, the states share OSHA's desire to bring this pandemic to a close, but the agency cannot pursue that laudable goal unlawfully. I welcome your questions.
So you're saying, Mr. Flowers, that the first step in OSHA's regulation is to identify the workforce, the problem in that workforce, and then regulate that?
Yeah,
That is typically how OSHA
great.
proceeds. I don't know if there's a requirement
So
that says they
normally
do that.
common
I think
sense would
part of
apply
the
to a
problem
rule like
is
this,
with
right?
rule,
You would
it's not
study
truly
the
intended
industry
to
first,
regulate
and then you'd see what the
danger.
problem is, and then you
It's
design
a
a solution.
danger that we all face
Not
simply
design
in
a
a matter of
solution
waking up
for
in
the
the morning.
problem that doesn't
I-
exist.
And
I'm sorry to interrupt
Looks like half
you,
the court
but
wants to argue to a conclusion
the other
versus
part of my
facts.
question is, can a danger be so acute in the society that it is brought into the workforce and could hence be regulated by its mere presence there and by the fact that it is so acute?
I think what they need, let me answer this in two steps. I can first define what we mean by work-related danger and then talk about how that applies here. And I think that'll get to your question. So in terms of what we mean by work-related danger, I think one way to think about that is, has the employer done or failed to do something that creates the risk the employee faces? And then the problem with applying that here is if you look at their own explanation for what the risk is, this is at 61,411 of the Federal Register. They say the reason there's a risk in every workplace is you come into contact with people at the workplace. When you define the risk that broadly, that is not something that's arising out of the workplace. That's a risk we face when we
If they
wake
strike
up,
it
when we're
down,
with our
do you
families,
think
when we stop and
Biden
get
will
coffee
give
on the
up?
way to work, at work, when we go to
Yes.
lunch, and in the evening if we go to a sporting event.
Getting
or a
too close
concert.
to
So this
2022
kind of goes to
elections?
Justice Barrett's
Yeah.
question,
I
believe.
think that's what
If
his
they
statement
were to
about
focus
the
on
states
a
are
risk
controlling
arising
what meant a couple
out
weeks
of
ago.
a
He
particular
felt
aspect
that he
of the
was not
workplace
likely
that
to
creates a
remember he
risk
said that
of-
about
a
the
risk
eviction
of a
order.
different nature,
He's
like
like,
the
yeah, it's just
impact
a political thing,
close
but yeah,
together in a
we'll
meat
lose.
packing plant. That could fairly be described as a work-related danger.
Mr.
But this
Flowers,
cannot-
sorry to interrupt. Do you know of any workplaces that have not fundamentally transformed themselves in the last 2 years? I mean,
Yeah,
maybe like
my workplace hasn't.
landscapers, they work outside. But I mean, this
Some of us
idea
didn't hit
that there are
panic
only a
buttons and
few
hide behind
select
our desks.
workplaces that are affected by COVID, I would have thought every workplace has been affected by COVID. Every
Don't watch
workplace sent their
MSNBC.
workers home. Every workplace had to make adjustments to the way they do their business.
Not really.
I'm
They can
trying to
choose
figure
to,
out like why
but
this
they
is a
didn't have
blunderbuss
to.
approach when
Especially
everybody
the outdoor
knows from living their
businesses.
normal lives
Absolutely.
that every workplace has been affected by this.
Like meter readers,
save
I don't think
for,
had to worry too
a
much
few
about
here
it.
and there.
You know?
So the way I would answer that is to say just about every workplace has been affected, but that doesn't mean the work is arising from the workplace. To take another example, if we look at terrorism, there's some risk of terrorism that we face when we wake up in the morning. We face it at
Good
home, in
analogy.
public, and at work. And we adjusted to that after 9/11. If you see something, say something, ideas like that. Now, the fact that you face that risk when you go to work doesn't make it a workplace risk. It means it's an ever-present
Why
risk.
It's not a problem
I mean,
inherent to the workplace.
this is
That's the
the
theory behind
combination
OSHA power.
of
Makes
lots
sense,
of
yeah.
people all going in to one indoor space and having to deal with each other for 8 hours, 10 hours, however many hours a day.
They don't even know what
In
most jobs
those,
are. That's what's so funny.
settings,
They have no
Most,
idea.
the combination
define
of
most.
the
Yeah, come on.
environment and the people that are in that environment create a risk, I would think. I mean, tell me if I'm wrong about this.
You're wrong.
I would think that workplace risk is about the greatest, least controllable risk with respect to COVID that any person has. You know, everything else a person can control. You can go to the baseball game or not go to the baseball game. You can decide who to go to the baseball game with. But you can't do any of that in workplaces. You have to be there. You have to be there for 8 hours a day. You have to be there in the exact environment that the workplace is set up with. And you have to be there with a bunch of people you don't know and who might be completely irresponsible.
I thought it was at will employment.
Where else do people have a greater risk?
They're
than
willing
at
to
the
fire people who
workplace?
don't do the vaccine, so flip the argument.
Well, I think one thing with their families that they have to spend even more time with, especially if they have children going to school and things of that nature. But in response to does the risk, of course the risk arises at the workplace, but it's important to focus on the risk they're talking about. They're not talking about jobs where people do congregate in settings like that changes the nature of the risk. They say every single workplace where people come inside for even a little bit is covered. And so they've defined the risk to mean simple human contact. And it could be no more contact than you have at the grocery store or when you drop your kids off at school or when you go to a friend's house.
All of this is practical political argument. None of it is legal.
Rule does is it
Nothing
says
yet
we're
so
not
far,
going
right?
to regulate some people who work outdoors, forget about it. People who work alone, we don't have to worry about them. But people who work in the way that lots and lots and lots of people work, which is surrounded by other people in indoor spaces, you know, without their own offices, you know, with cubicles or with in other mass settings.
Well, you're already qualifying it now. Now she's narrowing it down.
You know,
So
that's
she's
where the greatest risk is.
Barrett signaled them.
That's where the risk of ordinary life is. That is, in fact, where the greatest risk is.
No, it's not.
And if they had taken that approach, they would have a much better argument, but they don't, because there are many jobs here, including, for example, landscapers who may spend a little bit of time inside.
This has been demonetized. We're listening to the Supreme Court. That's demonetized. Is that not precious?
Says what I mean, my law clerks have been busy beavers on this case, I promise you. And what they have on this issue is that there are exceptions here. There aren't exceptions business by business, but there are exceptions, those who work from home, alone, or substantially outdoors, or those who can show that their conditions, practices, means, methods, operations, or processes.
Listen to all of this. None of this is about
workplaces
what power Congress gave them or not.
As the ETA,
what Commerce Clause, non-delegation doctrine, states' rights.
Okay.
None of it.
So they
It's,
did make
hey,
some
this is
distinctions.
scary, so we're going to do whatever we need to
Not
do,
in
and
the
we're just going to
industry,
say
but
it's
my question
constitutional and
really
just
is, what
ignore
I'd
the
like to
legal
turn
analysis
this to
because we want to. It's
is,
justify the means analysis,
stay.
and it's
we're
how
scared
scary
of
it
old.
is.
I asked.
Old and scared is what we
I
are.
mean, you know, 750 million new cases yesterday, or close to that.
There we go.
Is a lot. I don't mean to be facetious.
Can we have
I'm
Alex
pretty-
Berenson for
pretty sure there weren't
I find
750
it,
million new
unbelievable
cases.
No.
that it could be in the public
Guaranteed.
interest
Yeah.
to suddenly stop these vaccinations.
I don't even know if we've
And
had that
the only
many.
answer
We haven't
that
had
was
that many
given
cases worldwide
was
yet.
a lot of people will quit.
Correct, to my knowledge, but
well,
not within a single day.
OSHA considered that.
Yeah.
My wonderful law clerk has 61,475, 63,422, 61,466, 61,474, and 475. Those are pages. I don't think you should read all 61,000, but nonetheless, there are at least 5 or 10 pages where they went into this. And they said, in our view, yeah, that's right. Some people may quit, maybe 3%. But more may quit.
Yes, to Freddie's
They discover
question,
they have
yes.
to work
That
together.
was one of the arguments
with
made earlier
unvaccinated
by
others,
the NFIB
because
council.
that means they may get the disease.
Or that this is that a bunch of companies could not
And more will
institute
quit
testing, and this
because
was
they'll
getting back to
maybe
effect.
die, or maybe they'll be in the hospital, or maybe they'll be
How many
sick and
people do
have
you
to
think
stay
will
home
actually
for 2
quit
weeks.
if they don't
So they
do the
gave
mandate? They
pros
haven't
and
quit yet.
cons.
There was no mandate before.
So I'd
They
like
haven't
to
quit
take
yet.
Justice
So why would
Kagan's
they?
questions, which I
Their
think
estimate is that
share
they'll
on
lose
merits,
at least 3% of
and
employees.
just ask you, are
No,
you
but he's trying to
asking
ask the
us
opposite
both
argument
still
that if
Oh,
they
yes,
don't put it in, how many
issue
people are
a
going to quit? It's like,
stay
well, how many have
today?
quit? There is nothing in place
Tomorrow?
right now. They're still there.
Monday?
Right.
And why?
We are seeking an immediate, thank you for the question. We are seeking an immediate stay. As an initial matter, I think Alabama Realtors takes their arguments about the beneficial effects of their illegal action off the table. If the court considers it illegal, then it's not in the public interest and it's proper to enjoin it. Now, the court may say, or say it rather, the court may decide that there's a better way to unwind the illegal action than a judicial action. And I think that's what Justice Kavanaugh's concurrence in the first Alabama realtors got to. But what it can't do is say, we judge that these are very, in our view, this illegal action will lead to good effects. And so we will allow that to happen. To Justice Kagan's question about who decides.
Good point, right at Breyer.
The 2112.
The fact you think it's good politics means nothing.
The reason for that is they recognize that this was without notice and comment. And unless the courts could step in to abate illegal actions, nobody would be able to do so. And that's especially important here, where the
go back to the balance of power,
but at least strongly encouraging vaccination cannot be
trying
undone.
to sneak the law in?
Finally, the other point in the public interest is one awkwardness of this situation is that the ETS is focused on what was really a different pandemic. It's all about the Delta variant. Now we are on to Omicron. And as my presence here as a triple vaccinated individual by phone suggests,
big win by Aaron series.
The amicus brief
the FOIA case, and I have to disclose everything.
Vaccines do not appear to be very effective in stopping spreader transmission. They are very effective in stopping severe consequences, and that's
Speaking
why.
of which, remember that particular product or drug that they talked about being a veterinary medicine?
Yes.
What's the Pfizer CEO's degree in again?
Those numbers show that Omicron.
So I would argue that that's veterinary medicine coming from Pfizer.
Causes as much serious disease in the unvaccinated as Delta did.
Notice her argument.
Numbers, look at the hospitalization rates that are going on.
Back to politics.
We have more affected people in the country today than we had a year ago in January.
No surprise.
We have hospitals that are almost at full capacity with people.
Where are these hospitals that are all over capacity all across America?
We have over 100,000.
I don't know of any of them. What in the world?
We've never had before. In serious condition.
We're at less over capacity than we were in 2018 from the flu.
So saying it's a different variant just underscores the fact that without
this is from Michael Garcia. If you don't want commentary, folks, rules, you can go and listen to this live. We won't talk over it all. It'll just be pure feed.
Because this is not a vaccine mandate, and requiring masking.
Come on now,
and requiring isolation of people who have tested for COVID, because none of you have addressed that part of the ETS is to say something that should be self-evident to the world, but is not, which is if you're sick, you can't come into work. The workplace can't let you into the workplace, and you shouldn't go on unmasked. Tell me what's irrational about rules of that nature when it is the workplace that puts you into
why you don't need a vaccine or testing mandate in the first place.
Put you at risk.
You're symptomatic, you stay home.
That could be a good mandate. If you show symptoms, you go home for 2 weeks or whatever.
Many states subject to their own state laws that could impose it themselves or private businesses. So we're not making.
So if it's within the police power to protect the health and welfare of workers, you seem to be saying the states can do it. But you're saying the federal government can't, even though it's facing the same crisis in interstate commerce that states are facing within their own borders. I am not sure I understand the distinction why the states would have the power, but the federal government wouldn't.
The federal government has no police power.
It does have power with respect to protecting the health and safety.
It doesn't have general police power. It only has enumerated powers. But you would rewrite the Constitution to give them the same power.
Constitutionality of OSHA.
Mm-hmm.
Yes, I think you'd be asking if they had a police power to protect public health.
They have a police power to protect workers.
No, they don't.
I would not call it a police power. I think the Commerce Clause power allows them
Congress
to
does, maybe.
Commerce Clause power, not police power, as he just said.
It allows them to address health in the context of the workplace.
Exactly.
It's a good time to move to our sequential questioning. Justice Thomas?
Yeah, Robert stuck in now?
Mr. Flowers, there's been some suggestion, or at least it seems to be implied, that the vaccinations are efficacious in preventing some degree of infection to others. Could you talk about that, particularly as I remember in the filings, that the 18 to, that the younger workers, the 20-year-olds who are unvaccinated are actually safer than the older workers who are vaccinated. So there are obviously some differences. But you just talked about
vaccination doesn't work.
How
I love
efficacious
it. We know where he's voting.
is.
Yeah, exactly.
So first I want to be very clear. We are strong promoters of vaccination because they do stop serious illness. In terms of stopping infection and transmission, at least with the current variant, it appears, as the numbers suggest, to be far less effective. And then in terms of the comparison you were asking about, I think it's hard to define what's a grave danger in the abstract. What we can at least mandate, or at least demand from the agency, is internal consistency. And if you look at their own data, the CDC data from the last week of October, unvaccinated individuals 18 to 29 were as likely to die as vaccinated 50 to 64-year-olds, and 5 times less likely to die than vaccinated 65 and up. Hospitalization was between 18 and 49, that's not even just the young, was about as likely as vaccinated 65 and up. If you look at the Griffin study that they cite at 61,418 of the Federal Register, unvaccinated and vaccinated both had low risks of death in ICU. As a societal matter, we are not debating that COVID is serious. It is an incredibly grave risk for some people, not for everybody. And finally, I'd point you to the SCOTUS study. Again, they cite that 61,418 of the Federal Register says that vaccinated individuals who are 65 or older are twice as likely to die as unvaccinated individuals 18 to 49. And keep in mind that's 18 to 49, not 18 to 29. So it would probably be even more skewed if you looked at the younger demographic.
Would the state of Ohio have I'm not saying this would be an approach you would take, but you had earlier a discussion about whether or not the federal government had police powers in the workforce. And you suggested that the state has those police powers. Could the state of Ohio do what you say OSHA cannot do?
In terms of, yes, my position is the state of Ohio.
The states believe they have the power to issue
vaccinations, not only for workers,
I disagree
but
with
for
that.
all individuals. Now, I think that's an important point to stress, is we're talking here as though OSHA is the only entity that can regulate this, an agency that no one thought had anything to do with the pandemic until.
So we want more regulatory agencies? No, less.
And they're not sitting on their hands. And individuals are doing things to try and bring this pandemic to a close, or at least learn to live with it. Indeed, this court, without any requirement from OSHA, has found ways to safely conduct business.
I think my point is rather that there seems to be a suggestion that this is all or nothing, that the other
states can do this if it really matters.
Have police powers to regulate certain activities. And you've answered my question. Thank you.
Justice Breyer?
Quick question. I'm just curious. I was searching for an example. Universal risk inside and outside the workplace, including the workplace. Can OSHA regulate it? Can OSHA regulate fire risks?
Yes, we don't draw the distinction between.
If they can regulate fire risks, then why can't they regulate this risk?
Is this a fire?
Because the difference with the fire is that there's something about the workplace. For example, not providing safety equipment to put out the fire.
People throw matches. They smoke sometimes. Oh, they shouldn't, but they do. and or they throw a match. Or they, a lot of causes.
This is Justice Breyer.
Crushing people.
Well, can we prevent driving? Because people drive to work and they're at risk and they could die.
There's no limit, and they're not admitting that.
Catch it.
Sure, I want to be very clear about this. We accept the line that's been drawn forever in forging industries, that simply the fact that a risk exists outside the workplace doesn't mean you can't address it when it's inside the workplace. What we dispute is the idea that a risk that is ever present in all places can be regulated simply because it's also.
Well, yeah, basically states are going to.
They're already doing it.
To be clear, OSHA could regulate COVID-19 in the workplace when the employer does something like packing individuals very closely together in a poorly ventilated area that enhances or changes the nature of the risk, I should say. But that's not the risk they say they're regulating. Again, 61,411 of the Federal Register, they say the risk is you'll come into contact with individuals, and the risk of encountering an individual is an ever-present risk we face at home, at work, and everywhere else.
Justice Alito?
I want to come back to the question I asked Mr. Keller. in light of all that's been said this morning so far about public health, about the value of vaccines to the general public, because I want to make sure I understand precisely what the question is before us. And what I took from Mr. Keller's answer, which seems to be right, is that the question is whether there is a grave danger for unvaccinated workers, period. What the secretary said was, quote, employees who are unvaccinated are in grave danger from SARS-CoV virus, but employees who are fully vaccinated are not. So if this is to be sustained, it has to be on the ground that it presents a grave danger to unvaccinated workers who have chosen to be unvaccinated. That's my understanding of the issue, but maybe I haven't understood it correctly.
See where
Is
his
that
point's
your
going?
understanding?
He's saying the grave danger is for people who are going to quit rather than continue to work. So how are you solving the problem?
That is my understanding, and I don't see how there could be another understanding, because the emergency provision specifically says that such emergency standard, meaning the precise one they issue, must be necessary to protect employees from the danger at issue. So the broad societal effects are not at issue.
And protection of vaccinated employees who may face some danger of contracting the virus was not the basis for this rule.
That's not what Biden said. He said if I'm vaccinated, I wouldn't get it.
And I would go further and say they cannot rely at all on the risks of vaccinated workers, because they conclude, this is 61,419 of the Federal Register, that no one who's vaccinated is in grave danger.
Thank you.
Justice Sotomayor.
Counsel,
that was the conundrum.
Unvaccinated people you showed, or you pointed to young people who had a different or had the same death rate as vaccinated older people. But the point is that it's not the risk to the individual that's the question. It's that risk plus the risk to others. And unvaccinated people, and the agency has shown in its studies that unvaccinated people affect other unvaccinated people. And they vary in age and can be of ages and of conditions where the effect will be serious, if not death. So we're not talking, I don't know how comparing apples to oranges in terms of the risk factors makes any sense. But secondly, if the grave risk is to unvaccinated people, then how do we take that out of the equation? That it's not the risk just to them, but the risk that they pose to others, including unvaccinated people.
So I'll answer in two steps. On the apples to oranges, I think it's vital, because they have to be internally consistent. And their own logic is that nobody who's vaccinated faces a grave danger. So if unvaccinated folks of certain ages are at lower risk of death and even hospitalization, that is relevant to calculate.
But lower risk doesn't mean no risk. And lower risk can go into the calculus of saying, we see, and that's what they said, the risk to unvaccinated people of all ages and all conditions. And when you remain unmasked or unvaccinated, you put yourself at risk.
I don't think there's been a single legal or constitutional
others unvaccinated people
Sotomayor,
at risk,
Hagan, or Breyer,
and people who
it's
are
all been
vaccinated.
arguing policy,
They may be
because they have
risk,
no constitutional argument.
But the grave
I would argue,
and they don't care. They just don't care.
All ages
and justify the means
that are unvaccinated.
Right. But the problem is they define numerical probabilities that are equal to be grave in one case and not grave in the other, and that is the definition of irrational. In terms of spread, their own ETS says it's unclear the degree to which vaccinations reduce transmission. They appear to have a positive effect, and they appear, at least with Delta and previous variants, to stop contracting it in the first place. So again, if you look at the American Commitment Foundation brief, it's highly doubtful that the numbers are going to be comparable when it comes to the Omicron variant.
Justice Kagan?
Mr. Flowers, just continuing on that, if I understand your answers to Justice Thomas and to Justice Sotomayor, you basically said a couple of things. You said, well, we understand that 18 to 29-year-olds, even though they're not going to die or wind up with very serious injuries, that they can spread. you don't doubt that those people spread to other people who might be more vulnerable. You don't doubt that, right?
That's right, but the problem.
Okay, I'm sorry to cut you off, but I just wanted to state that as like the premise. And then the question is, well, you said, well, the agency itself says that the danger is to other unvaccinated people, older people, immunocompromised people, whatever.
Exactly, Josh.
And you seem to be saying that because it's to other unvaccinated people, they assumed the risk and the agency's power runs out. Is that what you're saying? Because I don't know about that kind of doctrine in the OSHA Act or any place else in administrative law, that because you can say that, somebody would prefer not to be regulated, the agency loses its power.
That's not quite the point we're making. It goes to 2 points. The first is necessity. So if everyone who's vaccinated is not in grave danger, then a narrower solution is, if they think they have the power to vaccinate, to require the people in grave danger to be vaccinated, and they are removed from the grave danger, and the other individuals are not affected.
If the vaccine works so much, the people who are vaccinated are inoculated, so they shouldn't care.
It's the problem they have. The down deep vaccine doesn't work, so they're really wanting to protect the vaccinated.
Question of who decides,
but they can't admit that because that concedes the vaccine doesn't actually work as advertised.
Exactly. So it is.
We all agree that states
cognitive dissonance in real time.
System. Congress has to regulate consistent with the Commerce Clause and make the major decisions, while
of course they have.
Agencies can do the work that Congress has given them to do, but not other kinds of work. And the major questions doctrine kind of regulates that interaction between Congress and agencies. So it's not that judges are supposed to decide some question of public health. It's about regulating the rules.
This is where I thought Robert was winnable.
Ensure that the appropriate
he has long wanted to restrict Commerce Clause power.
So the question, in
that's
my
probably
mind,
a good
really
thing.
turns a lot on.
Oh yes, it is.
In this case.
And now he's
This
going
one
right.
that
He's saying major questions doctrine is really a
agencies to
Commerce
decide,
Clause
one that Congress has to
He's
make.
saying
as
this
a
isn't about
major
judges
question
second guessing
under our federal
Congress.
system.
Congress doesn't have
I
this
haven't
power
heard a
in the
lot of
first place.
discussion about that.
Oh, I like that. I like that
The
opinion.
Solicitor
Actually,
General says the major questions issue only comes into play when a statute's ambiguous. I'd like to give you an opportunity to explain your view.
I think you can view the major question doctrine. The phrase is sometimes used in different contexts, and sometimes it is used as kind of an ambiguity clarifier, an elephant's and mouse hole's point. But another way to look at it is something of a constitutional doubt canon, where we recognize that although our non-delegation doctrine is not especially robust today, there are limits on the amount of authority that Congress can give away. And with respect to these major
That was a subtle reminder to Roberts that they need to reinvigorate non-delegation.
Millions of dollars and potentially many
He said it's not as robust as it could be.
Health, we would expect Congress, we would demand Congress to at least speak clearly before we will say an agency can exercise that power, and therefore before we're into the non-delegation issue. I do want to stress a non-delegation. I mean, if they're right about work-related danger, because I understand their rule, it's any danger you could possibly face at work. A grave danger is any danger that could even conceivably result in death. Necessary means useful, and through a temporary and emergency standard, you can require permanent abatement. If you put all that together, this is among the broadest and most standardless delegations of authority to an agency in the United States Code.
Exactly.
Exactly.
Justice
I'm
Kavanaugh?
glad they got around to that
I
point.
want to follow up on Justice Gorsuch's questions, which I think are important, and also Justice Kagan's questions about the policy arguments that are present here, especially in an emergency situation. So, as I understand it, you're invoking the major questions doctrine and your statutory argument to say that based on the Constitution's separation of powers, Congress must act or the states must act, and OSHA lacks authority under the current statutes to do this. That's your basic pitch, I think.
I think so, as long as this means the vaccine mandate. We're not disputing that they can regulate COVID-19 to some degree.
Okay. Yes, that's what I meant by this. I want to give you an opportunity to explain the value of insisting on that congressional action for something like this at the federal level in an emergency situation, and explain why we shouldn't defer more to the executive or defer to the executive in what has been characterized, I think appropriately, as a crisis or an emergency kind of situation. What's the value of insisting on that here?
Well, one value of it is that when there's an emergency, it's especially important that it be a considered, thoughtful process, and legislation is more likely to yield that. And in an emergency, you're more likely to get broad agreement on certain principles that can be enacted through Congress. And indeed, Congress has taken many steps to ensure that there are to address COVID-19.
Thank you.
Justice Barrett? Thank you, counsel.
So now it's this government, or it's the Medicare mandate?
General Prelogger?
Oh, okay.
And may it please the court. COVID-19 is the deadliest pandemic in American history, and it poses a particularly acute workplace danger. Workers are getting sick and dying every day because of their exposure to the virus at work. OSHA amassed substantial evidence of widespread workplace outbreaks across all industries. It studied the science of how this virus is transmitted and found that workers are exposed to danger when they're inside together for as little as 15 minutes. And OSHA considered the extensive evidence that unvaccinated employees are at heightened risk of contracting the virus, of transmitting it to others and infecting their coworkers, and of suffering the gravest consequences, hospitalization, and even death. To protect against that grave danger, the standard requires employers to adopt a policy that unvaccinated employees either get vaccinated or mask and test. Those are commonplace and highly effective measures that OSHA determined were essential to stopping the spread of this
Not commonplace.
at work.
Nothing about this is commonplace.
Portray
No.
this standard as unprecedented, but this lies in the heartland of OSHA's regulatory authority.
No, it doesn't.
Congress charged the agency
Nowhere
with
near it.
setting nationwide standards to protect the health and safety of employees throughout the nation. And
Mark
Congress
is here.
specifically appropriated money to OSHA to address COVID-19 in the workplace. Nothing in the statute or the agency's regulatory history bars the use of these measures.
Ouch.
Just the opposite. Section 669A5 of the OSHA Act specifically contemplates that immunization requirements can be imposed under the Act. And
Thank you,
OSHA has
Kalex.
previously protected workers with measures like masking, testing, and encouraging vaccination. OSHA had statutory authority to rely on those measures here, which it found would save 6,500 lives and prevent 250,000 hospitalizations in just 6 months. As the preamble to the standard explains,
Listen to how small that is.
exposure to COVID-19 on
They're
the
going to
job
mandate something on tens of millions of
covers
Americans.
OSHA's history.
You
I
think it
know.
will save 6,000 people?
That the
Maybe.
agency is powerless to address that.
It
grave
happened in
danger.
4 years when the side
welcome
effects
the
start to
court's
come up.
questions.
And
I mean, there's more people that die in car accidents. You might as well ban people from driving to
What's
work.
Well, I think you should. Get on it now.
problem You're getting
Exactly.
at
You've got
is
Ralph
the
Nader. Get a hold of him.
employer
No.
not,
Yep.
providing, making sure that employees are vaccinated or masked, or is it the employees who decline to be vaccinated or masked?
Well, it's the
Here's
grave
his point.
danger to
This
exposure
really isn't about
to
protecting
COVID-19
workers. It's
on
about
the
forcing them to do
streets.
something they don't want to do.
Who
Yep.
refuses to do that?
Right.
Ultimately, what the agency is
Well,
doing with these
it's
standards
kind of
is
the way-
requiring
look, she
that
won't
either
answer.
through a vaccination
No,
requirement
no,
or
no,
through
no,
a
no, no.
masking and testing policy, that unvaccinated workers who stand the highest chance of contracting the virus at work, of infecting others at work, and then if ultimately
Infecting
if they get
The
if
vaccinate?
they catch
Wait.
COVID at work, of then suffering death possibly or even hospitalization, are protected in all of those circumstances. So I think what this standard does is it regulates employers
Nanny
by
state.
requiring them to adopt a policy that will directly target that grave danger.
I understand that, but who is declining to do that? Is it the employer or the employee?
I think it can be both. There are many employers around the country that have voluntarily imposed these kinds of requirements with their workers in recognition that vaccination is the single most effective way to protect workers in the workplace, or that have used masking and testing requirements to the
Well,
same
that's all she
extent.
keeps
So
repeating
many
is the same
employers are
point.
doing it,
Won't
but
answer these are workers that are denying this. You're forcing this on workers in the name of protecting them from themselves. You won't
It's a contradiction because the lefty philosophy is all about the workers.
Exactly. And the whole basis of the law is to protect workers from employers not using their conditions
quite a bit of weight on the acute.
This is more questions than you've asked so far. I think it's boring.
That we're in. But would your argument also be, would your argument be the same for any infectious disease that is taken into the workplace?
It's like, where does this keep going?
No, I think that with respect
to
other infectious
we'll only do it for this
diseases,
one
it would
time.
be
Don't worry.
necessary for OSHA to develop the record to demonstrate that the requisite risk level that the
But you
statute
could.
requires.
I still say it's about
That's
getting
not that
everybody's
you would
papers.
do it, but could
I
you do it?
really feel that.
If there were in fact a grave danger to employees posed by another
point.
infectious disease, then yes, we think that Congress clearly contemplated that OSHA is obligated and charged with the responsibility.
Has OSHA ever done that?
OSHA has enacted any number of standards that address those kinds of threats. For example, the bloodborne pathogen standard that we have pointed to before was intended to protect employees from the risk of viruses that they can contract through bloodborne transmission. So
is that in the general workplace or just in healthcare?
Boom.
That standard applied anywhere where employees can predictably encounter bloodborne pathogens. So it wasn't just the healthcare context. It can apply to flight attendants. It can apply to janitors. It was a standard that directly targeted the exposure wherever it exists, just
That's
like this
problem.
one does.
Thank you.
It directly targeted.
You said
this one
just
does?
a short while ago that this
It's
presented
specific, not wide,
COVID presented a
not
great
universal.
danger to people in the workplace. In a few minutes, we'll hear an argument in the CMS case, and it will be that it presents a grave danger into Medicare and Medicaid facilities. Not here, but in the lower courts, the federal contractor mandate, the argument's going to be it's a grave danger to federal contractors. Could you give me examples of some federal agencies where you would be willing to say COVID is not a grave danger in that context?
Well, Mr. Chief Justice, I haven't, of course, surveyed the landscape of all of the different authorities that federal agencies can invoke.
But you represent them on a regular basis here, so you have a pretty general idea of some other examples of federal agencies. And my point, obviously, is that I don't think as more and more mandates and more agencies come into place, it's a little hard to accept the idea that this is particularized to this thing, that it's
He's coming around a little
regulation, that it's a CMS regulation, that it's a federal contractor regulation.
The excess of Commerce Clause power was going to bother him.
Trying to work across the
even though he has no problem with vaccine
just going
mandates.
agency by agency. I mean, this has been referred to the approach as a workaround. And I'm wondering,
that was the
wonderful slip.
What we're trying to do here, and what OSHA did, was rely on its express statutory authority to provide protection to America's workforce from grave dangers like this one. So I'm
just going to keep repeating myself over and over again. Grave dangers, grave dangers, COVID, COVID, grave dangers, COVID, COVID, grave dangers.
Of other agencies as well, but I think to suggest that this disease is so prevalent because
did you ask a question, Judge?
She's not answering. OSHA has less power to do anything about it with respect to
it's not so much that OSHA has less power. It's that the idea that this is specific to particular agencies really doesn't hold much water when you're picking them off one by one. I think maybe it should be analyzed more broadly, as this is in effect an effort to cover the waterfront. I'm not saying it's a bad thing, but I don't know that we should try to find, okay, what specific thing can we find to say, oh, this is covered by OSHA? What specific thing can we find to say that this is covered by the hospitals? What specific thing can we find to say, we're doing this because
it's obvious what they're doing.
It seems to me that the more and more mandates that pop up in different agencies, it's fair. I wonder if it's not fair for us to look at the court as a general exercise of power by the federal government, and then ask the questions of, well, why isn't Congress have a say in this, and why doesn't this be the primary responsibility of the states?
Congress absolutely has a say in this, and it spoke here. It passed the OSHA Act and promulgated Section 655C.
So it passed this 30 years ago. So that's when Congress had a role, 30 years ago. No, I mean, Congress should have spoken now.
The OSHA Act was enacted
Abdication
in 1970,
of responsibility. That's what they're famous for. Same with the war powers.
The preamble to this rule documented.
Well, what she won't admit is they wouldn't pass it. The Senate already said they opposed the vaccine mandate, and so they knew they couldn't get it through the legislature.
Well, Mr. Chief Justice, the court obviously has a statute in front of it that it needs to examine. I think that there is is no doubt that COVID-19 constitutes a physically hazardous agent within the meaning of this provision. I think that the immediacy and magnitude of harm here clearly constitutes a grave danger. Unvaccinated workers stand a 1 in 14 chance of being hospitalized, a 1 in 200 chance of dying. The country hasn't seen numbers like that.
It sounds like the sort of thing that
1 in
states
200
will be
chance if they're
responding to or
infected,
should
which
be,
is a certain
or
percentage, which is
Congress
less
should
than
be
1%.
responding to or
Let's
should
not
be.
pad the
Rather
numbers
than
too much.
Agency by agency, the federal government, the executive branch acting alone is responding to. And we're supposed to say, well, yes, this is a CMS problem. Yes, this is an OSHA problem. Yes, this is a federal contractor
Well,
problem.
as you pointing out, they're going to have to
The
pretend
military's on its own. They
that
take
these are
orders.
specific problems that are obviously the executive branch just
Again, I guess I'm
circumventing.
just repeating myself. It seems to me that we should be looking at it as an across-the-board issue, as opposed to, let's see what OSHA looks like. Let's see what CMS looks like.
Well,
General, I'm sorry, go ahead.
Go ahead.
I was just going to say, Mr. Chief Justice, that I think the court, in approaching issues of statutory interpretation and looking at agencies' regulatory authority, has always started with the text that Congress enacted for purposes of understanding whether the agency has power to act. And the fact that there are other agencies here that likewise we think are empowered to act to protect America against what is happening in this country right now shouldn't diminish the force of the express statutory authorization
But I think
here.
the question is this. I mean, it is a rather deep, in a sense, deep question. Can you, or maybe you did, could the White House say, issue an order to all federal employees? And what it says is every federal employee in any agency who has authority under a statute, which means all of them, to require those whom they regulate to insist that their employees be vaccinated, do it. Now, they can't legally tell you do it, but it's a strong policy. And that's what's happened. Now, I don't know the implications of that. I never thought of that. But I think that's what you're being asked. Is that?
I went to school with Breyer's daughter.
And I don't know you ever thought of it. But I mean, has that happened?
I think it's incorrect to say that that is what is happening here.
That is what happened. Yes, that's exactly what happened
I
here.
mean, has that happened generally? Has that happened? Did somebody issue such an order?
Justice Breyer, standing before you today, I'm not sure that I can think of a precise historical
No,
example of
No,
that.
no. In this instance, your answer, I take it, is no. There is no such order.
That's right. I mean, certainly, I think that that throughout this nation.
I don't want to put words in your mouth. Don't tell me there isn't such an order if there is.
No, I'm not aware of any such order.
Right, or something like that. Okay. I have one other question for you, which is because I'm operating between two things. One is the merits, which might be difficult. I don't know. I'm not taking a view on that. But at least they're difficult and could take time. And the other is the question of the stay. Now, on the question of the stay, I read from research that we've done, but I don't know if it's right, that the argument was, what about the argument that they've made? One is that, well, if we issue a stay today, tomorrow, more people will stay home and things will get worse. See? That was one of their arguments. And the other, well, all right, what about that? That seemed to me to be the main one.
As I understand the argument, they're concerned about worker attrition with respect to that particular claim. Yeah. And the agency gave sustained attention to this very issue. It spanned several pages of the Federal Register. The agency looked at surveys that attempt to analyze how workers will respond. It looked at the real on-the-ground practical experience of companies that had imposed these kinds of mandates and found that there was substantial compliance levels and that the concern that workers would leave in droves was misplaced. And then the agency further emphasized that it had provided to employers to adopt a mask and test policy instead of a
comments like
vaccination
this coming through the chat,
specifically because the employers are best positioned to understand their workforce and to know which of these options is going to ensure maximum.
This is true. He's actually she's losing Breyer. He's on her side.
You've heard and you've read the argument on the other side that look, what the OSHA could easily have done or should have done is go through industry by industry or groups of industries by groups of industries and say there's this here and there's that there.
Well, they had no business in this space, period.
Employees, except for, and then they had a few exceptions, working alone, working at home, religious exemption. You can prove to us that you have some other thing that's just as good. They went that way across industries instead of one by the other. That's one of their arguments. What would you say to that?
My response to that is that the secretary here cited overwhelming scientific and medical evidence that the grave danger exists based on how this virus is transmitted anywhere people gather indoors together. And that applies to a lot of workplaces, but that just turns
no, I
the
mean,
nature
that
of
was
how
the point
this
made by the
virus
Fifth
is
Circuit.
communicable
For
between
the Fifth
people.
Circuit
As
originally
Justice
granting the
noted,
stay was how little evidence there was.
often employees
In
have
fact,
little control over their work environments. They can't
What do you
control
think?
whether
He's
they
playing
can
to liberal judges who just assume this has to be the case. Everybody knows the
those
New
people are
York
taking,
Times,
what ventilation systems exist. And ultimately, OSHA determined
Russ is
that
asking if
anywhere
Breyer
there
might
is a
vote
risk of
correctly.
indoor
I doubt it.
transmission,
No.
there is a grave danger to unvaccinated employees.
Trying
Now, I
to
take the
persuade
point,
Roberts
as
and
the
was
Chief
trying to
Justice's
give her
hypothetical
arguments
focused on, I
to
think Justice
persuade
Breyer focused
Roberts
on this
why
as
this
well,
isn't a
that there are
one-size-fits-all
certain
sledgehammer.
workplaces,
And
factories,
people-
assembly lines, where the risk is even graver, where the danger and the chance of transmission is heightened. But I don't think that in any sense calls into question the Secretary's determination that there is a baseline grave danger in any work site where that inside risk of transmission can occur.
General, can we, I'm sorry.
Justice Alito?
She's trying to save it.
I just wanted to ask you a question on this issue of the commencement of enforcement and the issuance of a stay. This ETS was issued a couple of months ago, isn't that right?
On November 5th, that's correct.
Yeah, November 5th. All right. And it hasn't been enforced during that period. These cases arrived at this court just a short time ago. They present lots of difficult, complicated issues. We have hundreds of pages of briefing. We're receiving very helpful arguments this morning. Does the federal government object to our taking a couple of days, maybe, to think about this, to digest the arguments before people start losing jobs?
Well, Justice Alito, if you're asking whether it would be appropriate for the court to issue a brief administrative stay, certainly we think that would be within the court's prerogative if it thinks that it's necessary to do that. Ultimately, for the injunction that they're actually asking for here, the applicants would have to show an indisputably clear right to relief, which we think they can't satisfy.
Well, I'm asking about an administrative stay, and I won't get into an argument about indisputably clear, but your point is you think it would be appropriate or it would not be appropriate if we issued a short administrative stay? Or if we do that, are you going to say, well, they're causing people to die every day?
We do think that the agency found that there is grave harm every day,
kill
and the
people,
numbers
Judge.
are
You're
stark.
gonna kill 'em.
But there was that grave harm during every single day.
Hospitalizations over
Was there not that same grave harm during every single day between the time when this was issued and today?
Well, certainly, we think that the harm has existed and been present throughout, and the agency specifically set aggressive compliance deadlines.
Well, my answer, I asked a really simple question, and you have the prerogative to say, no, we think, horrible consequences are going to ensue if
For people out there, he's wanting to grant an administrative stay without a final stay so they can think about the case more.
This case.
Kick the can.
I'm not going to say
Smart
that,
by
Justice
Alito,
Alito,
because
if the court
Roberts was
believes
not
that
wanting
needs
to
a
grant a
administrative
stay, and
stay,
Breyer
then
was
of course
arguing
they
a
can
stay would be a
enter it.
You
disaster.
mean brief, don't
So
you?
he's trying to say, let's
Yes, we
let's
think
buy
that there
some
are
time.
lives being lost every day.
Well, brief
Wow,
compared
being
to,
lost
sorry,
every day.
brief compared
Yay.
to what? The months that it hasn't been in effect since November, whatever it is, and when the courts have been active in this area, or brief compared to what?
Well, Mr. Chief Justice, I think that the agency well explained that the employers who are covered by this needed time to come into compliance. The agency announced that it was exercising enforcement discretion because of the confusion that had been created by.
It was also to check the fallout.
Maybe it would be helpful for me to explain exactly what
like the truck drivers who said we're walking
deadline means with respect to compliance. The agency has announced that for employers who are acting in good faith, it is not going to enforce any of the provisions of this ETS until January 10th. And what that means as a practical matter is that employers need to be adopting their policies.
Prioritize language.
They need to be ascertaining the vaccination status of their employees. And as of January 10th, they need to be requiring masking for any employees who remain unvaccinated. So it's not as though immediately employees are going to be quitting their jobs or leaving in response to reverse predictions. On January
yeah, and I'm sure her voice carries through a mask.
People are dying. You need to be masking. People are dying.
Testing will kick in on February 9th.
So if we delay that one day, maybe I'm wrong, and please tell me if I am. But the numbers I read is when they issued this order, there were approximately 70-something thousand new cases every day. And yesterday, there were close to 750,000. So if we delay it.
So that's what Breyer got confused with 750,000 with 750,000
more people.
Those decimals are a challenge.
Otherwise, we
Yeah.
didn't delay it.
You know, if that was Thomas, it would be national news.
I don't doubt the
Oh, it makes
sure.
a ridiculous fact. They won't say anything about Breyer getting the previous fact wrong.
And if I'm wrong,
Oh, and it would be
you better
once
tell me I'm
again,
wrong,
Thomas.
because, I thought that it really did make a difference to people who might get. You have the numbers. I saw the numbers. Well, all right. Well, so what do you say now? You say it does not really not a problem.
Justice Breyer, we absolutely agree that this pandemic has been dynamic, that it is constantly evolving, and that the current conditions are
like the definition of
a
vaccine.
truly grave danger.
General, am I to understand from your previous answer that enforcement qua testing doesn't occur till February 9th, correct?
That's correct, Justice Sotomayor.
The only thing that would happen in the next few days, or up to now, everybody should have a plan in place, correct?
Correct.
There's been no stay. So starting tomorrow, the only thing that are required are masks, correct?
Masking for unvaccinated workers, that's correct.
That's the only thing that occurs. And so until February 9th, when the testing comes into effect, that's when the threat of resignations or expense comes into
So she's
effect,
ready to kick
correct?
the can too.
Yes, as I understand what the applicants are arguing here on the testing aspect.
So the need for an administrative stay, if we're talking about a few days,
say
is
no
really small.
stay because
very small.
nothing exigent
I
is pending.
certainly myself do not think an administrative stay would be warranted here, but I of course defer to the court on that.
All right, one other question, if I might, counsel. I want to go back to the Chief's question and to Justice Thomas's question, and in part to Justice Gorsuch's questions earlier. The issue of who should act and who can act. An agency takes a while to act, and it's acting under an emergency order or an emergency statutory delegation by Congress. And the chief says Congress should act. We shouldn't let every agency act. Could you speak about the relative both expertise and speed with which Congress can act to survey the countless work sites in our economy, to identify the health and safety hazards in each one, and to legislate with the granular specificity necessary to address the hazards in all of these different workplaces? I understood the fact that in an emergency, we should not violate the Constitution.
Agreed, Alex.
But I'm not quite sure what regulation of safe and
Well,
healthy.
maybe we shouldn't violate the
provision of the
Constitution, but maybe we
Constitution
should.
violates. But I want you to get to the general.
It's an optional
question some
document,
of my
Mark. It's more like
colleagues have raised.
guidelines.
Who's in a better position to act and why? And why is it in a better position to act constitutionally?
Yes, of course, Justice Sotomayor. To be clear, we think that Congress has already acted here in passing Section 655C to authorize OSHA to take this kind of swift action in response to an emergency situation. If you look at the plain text of the statute, we think that OSHA's standard clearly falls within the terms that Congress enacted. COVID-19 is a grave danger. It's a physically harmful agent, and the agency found that these measures are essential to protect workers.
It's never been applied to a
statutory
pandemic
language already
This was
exists.
about,
And to the extent
asbestos
that
in the
the applicants
workplace.
are
That's what
suggesting
these
that there's
rules
some
are for.
kind of
Not any
specific
of this nonsense.
authorization
Which is
requirement
controllable
here
and
that Congress had
specific.
to do more.
Yes,
I
to
think
the type
that
of
gets to the
job
heart of
and
your
what you're
question,
doing
which
and
is
risks,
that
and
when
they can be
this court has
mitigated or
interpreted statutes
considered.
before, it
And
hasn't departed
Yep.
from plain meaning and imposed that
Well, you
kind of
never give the
burden
federal
on
government any
Congress to
power they'll
legislate with that
misuse it to do what they
specificity
did.
and that granularity, particularly in an emergency situation like this one. And the applicants have pointed to no aspect of the statute that would warrant that kind of result here.
Yeah,
It's
but people
their
ask me why they
interpretation
issue
that runs
called
counter
general
to to express
Solicitor
statutory
General.
provisions,
The
Section
legal
term.
669A5, that specifically contemplates
Okay, I was
that
wondering about
immunization
that because I know
requirements
there's
can
the
be
Attorney
imposed.
General, but I'm
The
like, no,
American
he's not
Recovery
here.
Plan Act,
Unless something, well, we are
where
in a
Congress
trans
specifically
administration,
appropriated
so
$100
anything's
million
possible.
to OSHA
Sure.
and directed it, in the words of the legislation, to carry out COVID-19 related worker protection activities.
Well, you're saying that Congress acted. Don't complain that Congress hasn't done anything, and that, that was 50 years ago that you're saying Congress acted. I don't think it had COVID in mind. That was almost
Last time it
closer to the
acted was
Spanish
50 years
flu than
ago.
It is
It
to
did something.
today's problem.
He pushed
Now,
the envelope too far because that
I
triggered that
understand
response.
the idea that agencies are more expert than Congress. I understand the idea
I think they're
that they
helping
can
with
move
Roberts.
more
They're
quickly.
they're saying the wrong
than
things
Congress.
that are irritating.
But this is something that the federal government has never done before, right? Mandated vaccine coverage.
It's true that there has been no standard that looks exactly like this one. The federal government has encouraged vaccination, as this standard does, and other provisions like the bloodborne pathogen standard. And masking and medical testing of employees are common features of OSHA standards.
Well, is it that an important consideration that we should take into effect? For example,
Correct.
along with the fact
That's
that the
the
police
Taylor's
power
question.
to take
There's
such
no
action
limit.
is more
That's
commonly
the problem.
exercised by the states, and we've had many cases coming out of the states and municipalities that evidence that, and also that yes, 50 years ago Congress passed a general provision, but I think it's certainly hard to argue, and you're doing a good job of it, that gives free rein to the agencies to take. I guess this is invoking
this is
the
where
major
Roberts,
cases.
he likes vaccines,
Doctrine.
but he doesn't
It
like
gives free rein to the
non-delegation
agencies
doctrine
to enact
having this
such
degree of power. He doesn't like Commerce Clause
broad
expansion. What happened to
regulation
him
that
a couple
was
issues
certainly
that
unfamiliar to Congress
he's
in
not comfortable
1970.
with. This kind of
There are a
federal.
lot of elements to that question. I'd like to try to take them
So
in
he's
turn.
really, this is a very
I think
painful
that
day for him.
Congress did
Yeah.
specifically contemplate that there would be emergency
Because
situations
he probably loves
that
the
pose
vaccine
grave
mandates
dangers to
deep
workers
down.
throughout America, and it specifically empowered OSHA to take action in response to that.
Cognitive
I
dissonance.
understand the suggestion here that the standard is unprecedented, but I don't think it withstands scrutiny. If you look at the various claims that the applicants are making, they first object to the scope of the standard, the number of employers who are covered, but OSHA commonly issues nationwide standards that govern all employers throughout the nation with respect to risks that exist throughout the nation, and that describes
Not like this.
COVID-19.
It's very
There is
misleading.
substantial evidence here
In
to
other words,
justify the scope
if you
of
have
the standard.
asbestos in your workplace, you have to do A,
Go
B,
ahead.
C, and D.
And just
That's
to
a
close the loop
nationwide
with
injunction,
one
but it has
final
very little
response, which
effect
is to focus
on
on
just a
particular
small
mitigation
percentage
measures.
of
There
employers.
too, we think that there is no indication
And it's
that
never
Congress
been to
couldn't
force
have
employees to do
anticipated or
something they don't
intended
want to do,
OSHA to use these
which was
types of
Justice
measures to
Thompson's point at
combat
the
a
very
deadly
beginning of
virus at
the
work.
act.
Immunization is specifically referenced in Section 669A5. It is the single most effective way to target the spread of a deadly virus. And to think that Congress would have meant to preclude OSHA from encouraging vaccination, I think is inconsistent both with the text of the statute and with the broader history of immunization requirements in this country, which have commonly been imposed.
Thank you, counsel. Justice Thomas, anything further?
I'm curious. This probably doesn't go to the
what is
dispositions matter, but is a vaccine the only way to treat COVID?
It is certainly the single most effective way to target all of the hazards OSHA identified, both the chances of contracting the virus in the first place, the risk of infecting other workers on the work site, and with respect to the negative health consequences.
Nice sideways slide,
provides
non-answer.
protection on all of those fronts.
Thank you.
Justice Breyer, anything further? Justice Alito?
On the issue of whether you're trying to squeeze an elephant into a mouse hole, and the question of whether this is fundamentally different from anything that OSHA has ever done before, I want to see if it might be fundamentally different in at least two respects and get your answer to the question. Most OSHA regulations, all of the ones with which I'm familiar, affect employees when they are on the job, but not when they are not on the job. And this affects employees all the time. If you're vaccinated while you're on the job, you're vaccinated when you're not on the job. Isn't this different from anything OSHA has done before in that respect?
So two responses to that. First, of course, there's also a mask and test option here. So I think even on that analysis.
Right now I'm talking just about the vaccines.
So focusing just on vaccination, I think that that's a way to describe it, that it also provides protection when you're not at work, but OSHA was directly targeting and trying to provide the protection at work. And I don't think there's any basis in the text of the statute to think that this kind of protection is off limits.
Suppose this is a little science fiction, but maybe it will illustrate a point. Suppose that this protection were provided not by the administration of a vaccine, but by waving a wand over employees when they arrive at work. And suppose that wand also had the capability of taking away this protection when the employee leaves work. Would OSHA have the authority to tell employees, you must have this wand waved over you when you arrive, but you can't have it taken off when you leave?
No, I don't think that OSHA would have that authority.
All right, so it's different in that respect. And here's another respect in which it may be different. And I don't want to be misunderstood in making this point, because I'm not saying the vaccines are unsafe.
Even they're
FDA
terrified.
has approved them. It's found that they're safe. It's said that the benefits greatly outweigh the risks. I'm not contesting that in any way. I don't want to be misunderstood. I'm sure I will be misunderstood.
They all are.
I just want to emphasize I'm not making that point.
Oh, no.
Is it not the case that these vaccines and every other
drugs should
vaccine
be treated like drugs,
and many other
a label on it, and magically
have benefits, and they also have risks, and that some people who are vaccinated and some people who take medication that is highly beneficial will suffer adverse consequences? Is that not true of these vaccines? And if that is that true?
That can be true, but of course there is far greater risk.
Won't say it is true.
By orders of magnitude.
Right, there is some risk. Do you dispute that?
There can be a very minimal risk with respect to some individuals, but again, I would emphasize that I think that there would be no basis to think that these FDA-approved and authorized vaccines are not safe and effective.
No, I'm not making that point. I tried to make it as clear as I could. I'm not making that point. I'm not making that point. I'm not making that point. There is a risk, right? Has OSHA ever imposed any other safety regulation that imposes some extra risk, some different risk on the employee?
That historically
so
just reduces the risk. It doesn't add
on the job. Wearing a hard hat has some adverse health consequences. Can you think of anything else that's like this?
I can't think of anything else that's precisely like this, but I think that
should have had that answer ready, darling.
Is precluded from using the
that was a good question though about the compared to hard hats, because you can take it off when you leave, and
would be a departure from how this statute should be understood.
Can I just say, General, that regulators think of risk trade-offs constantly when they make regulations.
Oh, thank you, regulators. Thank you.
In which there are risk trade-offs. Risks on both sides.
Regulators, because they connect to regulators as part of the professional class rule. That's why they love the administrative state. And they're very
true. And one of the
they're not. They didn't do their job here at all. None of these
risk that unvaccinated workers pose to other workers, because they are so much more likely to transmit this deadly disease to them.
That's false. So that statement right there, that unvaccinated people are much more likely, they didn't prove that in the rest of the
book. No, especially now. It's starting to come out.
Yeah, the grave danger finding is limited to unvaccinated workers who are far more likely to contract it from their coworkers as well.
That's not a concern for us, is it? We can't sustain this on that ground.
Thank
you. This is helpful to the vaccinated workers because the unvaccinated workers present a risk to them.
Oh, to be clear, they present a risk to other unvaccinated workers who might be older, who might have other comorbidities.
Have balanced the risks differently.
God, they just repeat the same point. They never shift.
But they want to balance the risks presented to their health in a different way. And OSHA says, no, you can't do that. And that applies when you're on the job and also when you're not on the job and for the rest of your life, because you have to take these vaccines, unless the testing option is valuable.
Well, one small factual correction, if I could, and then a broader legal point. I think it's wrong to say that everyone who's unvaccinated is just assuming the risk. Some people can't get vaccinations for medical reasons. Some people have deeply held religious beliefs and are entitled to religious exemptions. And OSHA
even more to the point,
protect those unvaccinated workers, no matter the reason they're unvaccinated. Just on the broader legal point, the idea that OSHA is powerless.
We're going to protect unvaccinated by forcing unvaccinated. Did you hear this?
How the OSHA Act has been understood.
that's what
its
Alito's
history,
exposing.
OSHA frequently
And
requires
she doesn't want to
employers
acknowledge what she's
require
doing.
that the employees use protective gear or take precautions. It's not.
And it was Thomas's point at the beginning.
There's this strong reason for saying that it isn't a defense to an OSHA Act charge that the employers assumed the risk
we have a prize in the
voluntarily,
chat.
that under most circumstances, employers
Well, he's got a
have an
link. He could
incentive,
jump in fully.
to avoid compliance with, to avoid the costs and inconvenience of a regulation. And so we don't want to have put the employees under pressure, overt or implied, to waive the protection of a regulation, a protective regulation. But there's no such incentive here. They're free. The vaccines are free. And to the extent they're
not free.
Workers healthy and on the job.
He means that
it's
it's not like you have to do this in order to make it affordable for employees.
The
If
fact
an
that
employee
workers
wants the
in the past
vaccine,
have
they
not
can
wanted
get
to
the
use
vaccine
certain
for
protections
the
has
most
not
part.
provided a defense to
Yeah, I hate that
regulations
free
have been
thing
issued
though.
under
It's
the
like calling
OSHA
library
Act.
books free. No, taxpayers do pay for them.
Counsel, if I might just go
Free
back to
to the
Justice
employee.
Alito's question,
Direct.
there's no vaccine mandate here, correct?
That's correct, and that's what
This
I
is their
started with. That of
pretending.
course,
I
any
mean,
employer
it is what
can
I
offer
said
the
all
mask and
along.
test option
This is a
instead.
testing mandate.
So really
for
the
vaccine
question is
exception.
between
But functionally, it was always going to work as a
masking
vaccine
and
mandate because then
testing
employers
and
didn't go
or
through the cost
vaccine,
of
but
a
no
test.
employer is being put at risk
Right.
greater than they choose to undertake themselves, correct?
Yes, that the employers have the choice to adopt either
listen
of
how
those
much of this is
policies, and
policy.
OSHA estimated that 40% of
Very
employers would
little
adopt
law.
the mask and test policy.
Number two, with respect to the issue of whether a person
a
has
cool looking
chosen to run the
background,
risk by
David.
being unvaccinated.
It's a
You point
playroom.
out that
It's
some
not-
people can't.
not
for
mine.
a
It still looks
variety of
cool as
different
hell.
reasons.
It's got a neat
But the
graffiti
risk here is not
vibe.
just to the person,
hair
it's
goes
to
into it.
everybody.
You know what?
else
You
they
look like
put
a
at
live
risk, correct?
thumbnail.
That's correct. The grave danger finding was premised on unvaccinated individuals.
They want
but
to
OSHA
compel
emphasized
vaccination
that
to
ensuring
protect
that
the
unvaccinated
unvaccinated who
individuals are
can't
not
get
spreading
vaccinated.
the
I
virus
know
in
it
the
was-
1/10 of
workplace
1% for the
will
one.
protect
And
everyone they came in
exactly,
contact
the
with.
number of people who
So there may
cannot
not
get
be a grave
cannot
danger
get
to
the vaccine
other people, but I
for
don't see why
medical
OSHA has to
reasons
close
is
its
tiny
eyes to the
in the
fact
workplace. Tiny.
Well, they did
they
throw in religious
place
exemptions
grave
because
risk
now they
to
care about
unvaccinated
religion.
Yeah,
and
yeah,
substantial
exactly.
risk to other people, correct?
That's right, and
They
OSHA
found God
specifically
overnight.
emphasized that vaccinated individuals may still be at significant risk. It wasn't ruling out that possibility. Its grave danger finding was focused on all of the ways
Have you
that
met lawyers
being
with this kind of voice?
unvaccinated
Even?
contributes
Guys,
to the
it's
spread of this
crazy.
disease.
It's
Is-
like a
is the
younger.
Vocal
listing
fry.
alternative
It's a
viable at the
vocal
present
fry.
time,
It's like
in
a
light of the
California
stories that
thing. And
we see
but of course,
about
if males
long
comment on
lines
it,
that
we're
are
called
required to be
misogynistic
tested?
because
The agency
professional
gave
women
sustained
tend
attention to
to
testing capacity
deepen
in
their
the
voice
preamble
like
to the
Elizabeth
rule. It looked
Holmes
at existing testing
to help.
capacity and projected
Oh,
out
I'm not going to say that all
of what
professional women are
additional
conning, but
capacity
that's
would be
what she was
necessary
doing.
for
That
employers
whole
that choose to adopt
hi.
the
Well,
mask
I'll
and
tell you,
test
I've
policy.
seen
both
jobs.
of their
There would
voices
be ample
irritate me, even the
testing in order
judge.
to
So
comply with the
I think
rules.
this entire
I'm obviously
circumstance
familiar with
irritates me.
the news stories that you're referencing, and I think that the agency could adjust if that proves to be a problem. But with respect to reviewing this rule, there was certainly a substantial basis for the secretary to conclude that this was a viable option.
Justice Kagan? General, I'd like to ask the government's views of the major questions doctrine that a number of my
I thought they were going
colleagues
to do
have asked
1
about.
hour
And as I see
for
it, there are
the
sort of two
OSHA and then
ways
another
that such
1
a
hour
doctrine could
for
operate.
Medicare. They're
One
going to do
is
2 hours
with
just on
respect
OSHA.
to ambiguous
Wow.
statutes, ambiguous either because they're
Do you think
vague
they're going
or
to skip
because
it,
there are
or
statutes
I
that
mean,
seem
No,
to
they'll still
have
do the Medicare mandate. That'll
conflicting
just go
provisions, where they
long.
point
Just
both ways.
keep rolling?
And
Okay.
then the
yeah.
major questions
I'll
doctrine is an
reschedule my noon
aid
one,
to interpretation of that statute. It's
or just
essentially
bring
a
other
kind of
lawyers in.
clue about how you should interpret a very difficult to understand statute. And the second way is there's really nothing difficult to understand about this. The agency action falls within the scope of the statutory authority. There's just no question that it does. And yet, because
Ludicrous
the agency
claim.
action is kind of a big deal, we're just going
Okay,
to
it's a
ignore the
big
fact
deal.
that it falls clearly within the scope of the delegated authority and say that notwithstanding that
Let me
that's
see if
true,
I still get sound if I do this. Oh, we
Congress
still
has
have
to
sound.
re-up it. So
It's in
I
here.
think I'd like you to talk about those two
Here, I'll
versions
fix
of
this.
the major
There we go.
questions doctrine with respect to this rule. What do you think of those two versions, and which of the versions potentially applies here?
I think that perfectly encapsulates the two versions, and we think that this court's precedents clearly demonstrate that it's the first version that you articulated is the way that the court has previously considered economic and political consequences.
The whole courtroom
so it's never been the
dialogue
case that the
drives
court
me
has
nuts.
started at the outset by saying, does this seem like a big deal? Does this agency action have a lot of consequences? And then use that as a basis to depart from the plain language of the statute, or to say, Congress has to specifically authorize it. We're not going to give the statutory text its ordinary meaning. Instead, in the cases where the court has looked at those kinds of consequences, it has always identified a conflict with other express statutory language, a conflict with other statutes that Congress has enacted that directly address the issue at question, or a conflict with the entire structure of the statute such that it would be unrecognizable to the Congress that enacted it. And it's only been in those situations where the court has identified a textual and structural problem with the agency's interpretation
they thought
at the beginning,
they passed OSHA to do vaccine mandates,
that the court has then gone on to say that its interpretation is confirmed by the consequences that would ensue.
If this Congress supported it, it would have passed laws. It didn't. That's what they're hiding. If this Congress supported it, there would be a law supporting it. There isn't. In fact, they've passed something saying they reject this.
Ultimately do a disservice to principles of the separation of powers and to Congress's ability
separation of powers. Imagine saying separation of powers with a straight face in this context, arguing for OSHA. What's separation of powers? There's none. The executive has it all.
My question
well, it's the same logic as we want to pass a mandate and force unvaccinated to vaccinate to protect the unvaccinated.
Yeah.
We're getting into some logical loop issues from hell.
I think we all agree on that. And here our choice on the one hand is a federal agency, and on the other hand, the Congress of the United States and state governments. Now,
have you been in front of SCOTUS?
Consider the major questions doctrine.
I'm a member, but I've never had oral argument in front of
statutory ambiguity. I understand that.
Can't wait till you do.
Let's say the court does find
the background's better than the bathroom.
I know you'll contest the premise, but let's just.
Oh, I think it's awesome. At least it's something.
I kind of like it. It is fitting with the overall
question that therefore belongs to the people
a man's descent into madness.
States and in the halls of Congress. Given that the statute at issue here is, as the Chief Justice pointed out, 50 years old.
Chief Breyer is trying to argue to Roberts.
The rule affects, I believe, we're told 80 million people, and the government reserves the right to extend.
This is frequently what's happening in oral arguments. Justices are arguing to other justices by the question.
States have had the responsibility for overseeing.
Somebody's got to do a good argument.
Mandates.
Yeah.
I rejected a challenge to one just the other day from New Mexico. Congress has had a year to act on the question of vaccine mandates already. As the Chief Justice points out, it appears that the federal government is going agency by agency as a workaround to its inability to get Congress to act. The risks imposed here are not unilateral. There are risks to those who choose not to be vaccinated that they're trying to avoid sometimes, as you discussed with Justice Alito and conceded to him. Traditionally, OSHA has had rules that affect workplace hazards that are unique to the workplace and don't involve hazards that affect individuals 24 hours a day. So that's kind of the general tick list we have before us. And I'd just like you to address, again, the question, assuming the statute's ambiguous, why isn't this a major question that normally under our Constitution would be reserved for the people's representatives in the
He's
states?
asking her to make his argument to Roberts as to why the major questions
the assumption that there's an ambiguity, which of course we disagree with, as you know. I think that many of the factors you identified are just simply inconsistent with the whole premise of the OSHA Act. So it's true that states have a police power over health and safety, but as this court recognized in the Gade case, Congress in enacting the OSHA Act specifically brought the federal government into the role of protecting the health and safety of
OSHA Act
workers
means the
and
OSHA Act,
displacing and preempting state law in that field. And so I think the idea that simply because states have that residual police power provides a basis
just because states have the power doesn't mean we can't do whatever we want whenever we want and discriminate them.
Specific authorization here.
That's not the argument Breyer was hoping she was going to make. That's counter to what Roberts wants to hear.
The fact that Congress, OSHA has not traditionally mandated other vaccines for other hazards that pose a
Maybe
grave,
down deep she
grave
thinks
risk.
there's no
Some
chance
might
they
say
win. It's
the
just
food
not.
kills
All she's
people
done is
every
repeat her
year.
core
Other
arguments,
grave diseases
not
do too.
not listen to where they're coming
There are
at, who they're
vaccines
arguing
against
to, where
many,
she needs to go.
and we don't need to list them all. But traditionally, OSHA
By the
has
folks who
not
do not want to hear
regulated this area.
commentary, I'm putting the link in
I
here
think that
again.
that's
You
explained
can
by
listen
the
to a
fact that
clean
COVID-19
feed
is an
with nobody
unprecedented
talking
pandemic that has a
whatsoever.
magnitude and
So
proportion
please,
that OSHA has
have a
never
nice
seen
time
before.
and
I
check
mean,
it out.
people forget polio, but that was a pretty bad. You
Is
can
this
call it a
Gorsuch?
pandemic. You can call it an endemic. I don't know what you'd call it.
Sounds like
It was
Breyer.
a terrible scourge on this country for many years. We have
Breyer was hoping she would talk
vaccines
about
against that. But the
Yeah, they're
food
letting him down. I
atrocious
hear
so
him
far as
trying to
I've
say,
known, you can correct me,
Yeah,
there's
please
not
go
any
here, please go
worker
here, please do
in
this.
the country
And they
to
didn't
receive
come in
such a
prep.
vaccine. We have flu
This
vaccines.
was not
Flu kills
unpredictable that Roberts,
lethal
Kavanaugh, and Barrett were your three
people every
undecided
year.
judges, and you
OSHA's
had to have
never
arguments for
purported to
them.
regulate on that basis. Well, what do we make of
But
that?
Breyer's the only one really
About
doing
what
effective stuff.
qualifies as a major
Sotomayor
question and what
and
doesn't?
Kagan are just
Well,
saying,
with respect to
you're repeating
other
the scary,
diseases where
scary
there are
virus.
Danger,
Lots of people are
danger,
gonna
vaccinations,
bad
I
die.
think the
So we
simple
have to let the
explanation
government
why
do whatever
OSHA
they
hasn't
want
had to
because it's an
regulate workplace
emergency. It's a
exposure to that
pandemic.
is because
That's not going to
virtually
persuade
all
Roberts,
workers are
Kavanaugh, and
already
Barrett.
vaccinated. With respect to
They
many of
needed
those
to go more
diseases, all of
specific, and
us
they
have
haven't.
at one time or another been subject to compulsory
Is that
vaccination
true with the
requirements,
flu?
mostly.
Do we know that to be true with the
So
flu?
flu is an exception because it's a seasonal illness. And
Oh.
there, I think that the
You mean
explanation for the
like
failure to regulate
COVID,
is that it doesn't
that
present
vaccines
anything
don't work against
approximating
it?
the kind
You
of
mean that?
hazard or
Well,
danger to
they could
workers
just show the
as
graph. If they
COVID-19.
deny this is
I don't
seasonal,
want to
I mean,
suggest
that
that it
just,
would
you
be
just don't
it
trust your
doesn't pose
eyes.
a
That's
grave
what I'm
risk?
saying.
Yeah.
Oh,
I
yeah.
think that the agency would have to build the record to demonstrate that it would clear that statutory hurdle.
But it might.
Oh,
It
yeah,
would
you're right.
depend
This
on the
is
evidence.
correct.
Certainly,
That's
if
correct.
there were another 1918 influenza outbreak like the country experienced before, yes, absolutely. I think OSHA could regulate exposure to influenza in the workplace. That's similar to what's happening with COVID-19 right now.
So she's sucking and blowing here.
Justice Kavanaugh?
I want to follow up on
That's a
Justice
very good
Gorsuch's and
specific
Justice
term.
Kagan's questions with how the major questions doctrine applies, and really first zero in on this question of ambiguity. We've used words like vague, subtle, oblique, cryptic, and ambiguous to describe the kind of language that would trigger the major questions doctrine if it is a major question. We haven't only used the word ambiguous. And it seems to me that a question that I'd like your help on is applying language that is subtle, cryptic, oblique to a new context hasn't been done before in the last 50 years. Is how do we think about a question like that? And in answering that, think about the benzene case, the Brown and Williamson case with tobacco, benzene with cancer, and the UARG case with greenhouse gas emissions. All three where the agency was applying this broad but arguably cryptic language to a new context. I think that's one way to characterize them. How do we think about that?
Well, I think Justice Kavanaugh, looking at those three cases in particular, that the reason the court concluded that the language was cryptic or oblique was because it identified other textual or structural reasons that ran counter to the agency's interpretation. So in the utility air case that you referenced, the court observed that the asserted regulation would overthrow the entire statutory scheme. The agency had
For people
conceded that
asking,
it was
major
never what
questions
Congress had
doctrine means that when
intended.
Congress
So
gives
that was a
power
structural
to the
indication
executive
that the
branch, it
agency's
must do so
regulation was
specifically
impermissible.
and with
With
clarity
respect to the
if it
benzene
involves a
case,
major
there too,
question,
there was a
meaning the
question
scale
about
and
whether
scope of its
there was an
impact.
entitlement to
So if
regulate
the
without any
agency,
finding
and
of
so the
risk, and that was in
phraseology
tension
that
with other
Scalia, I think,
statutory
once
provisions, so
you
there
and
was a
Alito talked
conflict.
about
And
today
with the Brown and
is, are you
Williamson case
trying to
that you
put an
mentioned, the
elephant
court
through a
chronicled a
mouse hole?
long line of
That's
statutes
the
that had
phraseology.
directly
Are you
addressed
saying,
the
you know what, we
issue
really
of
have this
regulation of
huge
tobacco
power
products and would have been
to
flatly
regulate the
inconsistent with the
entire
agency's
economy or
asserted
civil
jurisdiction.
society
So there's
in
never
this
been a
little
case where the
statute
court
over
has
here?
just confronted
And we've
broad
never used
language
it.
and
And
said,
that's what's called
oh, it
major
seems cryptic
questions.
or oblique,
You're
and so it's a
claiming
major
major
question, and we're
power.
not
Another
going to
way
give
to
it
think
its
of it.
plain meaning. In all
And
of
they're
those
saying
cases,
Congress
there
has
was
to give
a
clarity.
textual and
That's
structural reason for
it's
the court to
correlated
conclude
to
that
the
there was
Commerce
something wrong
Clause
with the
power,
agency's claimed
which is what
authority.
Roberts
In all
was
three
raising.
cases, there
And
were
the reason
strong
why Barrett
dissents
is
that
talking
said
about
the
it,
opposite
Kavanaugh
of
is
that,
talking
though, that
about
said
it,
actually this
and
statutory language is
Breyer was talking about it, is because it's
clear,
clear
and that the
Roberts is
court,
concerned.
Justice Marshall's dissent in the benzene case is very powerful, that the court was simply scaling back from the plain language because of of its concern about the significance of regulating every workplace in America to take out any risk of cancer. So there were dissents that made that point, but the majority seemed nonetheless to apply the major questions doctrine.
There were certainly dissents in those cases that thought that the statutory terms could get the agency there. But here I think the critical difference is that the applicants haven't pointed to anything in this statute that approximates the kind of textual or structural problem that has prompted the court to look at those kinds of consequences before. And it would be their interpretation that creates those problems. They would render superfluous Section 669A5's specific recognition that immunization requirements can be imposed under the OSHA Act itself.
This is the procedural liberal approach. Well, see right here in this little text here, we can do all this. It says so right here in this little text. And unless there's another little text that says we can't do it, then we can't. That's not what major questions doctrine is about. It's not been the fundamentally text-driven analysis in that
to the plain language of the statute.
Then one other question related to this, sorry to prolong this, but Congress has specifically referred to vaccines in a variety of contexts. Immigration contexts, those statutes authorized specifically by language vaccines. Military contexts, which you would expect, at least the anthrax vaccine is referenced in the military statutes. The National Childhood Vaccine Act, passed in '86, refers, and that's a different context, but dealing with vaccines. And so that's one point. And the other is, since it forever, but 2005, President Bush gave a very detailed speech kind of predicting what has happened. And it's eerie to read it. And yet, in the years since, there has not been at least a vaccine statute passed by Congress to deal with this kind of thing, even though he, in the wake of 9/11, but still was putting the country on notice of this problem that was going to hit us at some point.
Well, I certainly recognize that there are other statutes where Congress has specifically referred to vaccination, and I think that maybe that would get the applicants some traction here if, for example, this act specifically referred to other mitigation measures and illuminated what kinds of things OSHA could do and left vaccination off the list, but it doesn't do that. And so I think to suggest that there is some negative inference to be drawn is inconsistent with how Congress drafted this statute in recognition that OSHA would be positioned to understand the kinds of control measures that are necessary against the variety of workplace hazards. And if I could just make one additional point on that, of course, as I've emphasized, there is an express reference to immunization requirements in the OSHA Act itself. So we think that that actually provides additional confirmation that Congress was thinking about that and could have anticipated it, and that religious exemption would have no application if, in fact, immunization is just off limits. But I think, as well, it's important to look at this against the backdrop of immunization requirements in our country. This is not some kind of newfangled thing. As I've mentioned before, most of us have been subject to compulsory vaccination requirements at various points.
Robert, when she talks about compulsory vaccination in other contexts, was there a criteria as to the efficacy of the actual vaccine?
I mean, what she's talking about is just schools and kids. So most people have not been subject, I mean, other than the military. Most people, and in occasionally hospitals with flu vaccine. Or what, you know, they don't like to call it the flu vaccine because it doesn't quite work like the vaccine's supposed to work, so they call it the flu shot, of course.
Two questions, both of which address the status of this rule as an emergency temporary standard. So my first question has to do with the question with which Justice Thomas opened, which is the meaning of necessary. So of course, when OSHA passes a rule through its regular regulatory process, it has to go through notice and comment, and that's a way of holding an agency accountable. All affected people have an opportunity to comment, and the agency develops a robust record. With an ETS, of course, the agency can circumvent that process so that it can act more quickly. So for an ETS, we would want that power to be the exception, not the rule. And one contrast that the applicants point out between OSHA's authority to issue an ETS versus a regular regulation is that for its exercise of power in the normal course, it need only find that a regulation be reasonably necessary, but for an ETS, it has to satisfy a necessary standard. Now, you've argued, and I think there's a lot of intuitive appeal to this, that when you're facing an emergency of the magnitude of this pandemic, that this power effectively can be used most effectively as a blunt instrument. You know, we don't have time to make industry by industry specific kind of calculations because we want to move with speed. But how do you reconcile that understanding of necessary with the broader reasonably necessary standard in OSHA's normal regulatory authority?
So we certainly agree that the emergency temporary standards reference to necessary as contrasted with reasonably necessary and appropriate is a heightened burden and includes a measure of tailoring that's necessary with respect to the particular mitigation measures. But I don't think that that helps the applicants here because they haven't come forward with any alternative mitigation measures that they think would equally protect the workers that OSHA found were in grave danger.
But do they have to come forward with that evidence, or did OSHA have to consider it and reject it? Because another part of their contention is that OSHA did not adequately explain why this measure, this particular rule in its scope, was necessary vis-a-vis or as compared to other possibilities.
Well, OSHA explained that at length over dozens of pages in the 150-page preamble to the rule. OSHA specifically explained why vaccination as the single most effective way to target all of the ways that the virus threatens workers in the workplace was a necessary measure here, and it further explained why masking and testing would be essential.
Can they look at stats from Canada? 80+% fully vaccinated and record cases. Can they look at that?
Into the workplace.
And in fact, their evidentiary record was very thin. And in fact, they concluded that it might work. They didn't conclude that it would work.
As I understand their tailoring arguments, and this actually
probably reduces symptoms, reduces hospitalization in the vaccinated. Okay, but if it doesn't reduce cases,
they haven't suggested
it does for the purpose of reducing
infection. Neglected to consider. They're saying those things should have just been carved out altogether. But that is inconsistent with the Secretary's judgment that all unvaccinated workers face a grave danger and that the risk exists anywhere that employees are gathered indoors
all
together.
Unvaccinated
and again, there might be subcategories in those groups that are in graver danger, but I don't think there is any basis on this record to conclude that the agency lacked substantial evidence to draw the lines that it did.
That's helpful.
The vaccinated workers who pose a danger to the unvaccinated.
Again, about the status
carrying the virus
of
and not even knowing it.
ETS. So Chief Judge Sutton pointed out in his dissent from the denial
Everybody's
of
at
initial en
risk.
banc that
We're all
OSHA did
gonna
not
die.
adopt this rule in response to the quiet emergency, because that had been ongoing since early 2020. But instead, it responded to new facts on the ground, which included the widespread availability of a vaccine.
They really are
that
going
made
long
it
in
a
this one,
surprise
Robert.
Many people chose to forego, and the emergence of the Delta variant. And Chief Judge Sutton pointed out that in an extended pandemic, or I don't know if we've moved to an endemic such as this one, facts will continually change. New variants will emerge. There might be new
Facts will
treatments, new
change.
vaccinations. We
That's
have
beautiful.
boosters
Well
now,
put.
right? So now full vaccination might not just be the 2 jabs. It might include a booster as well.
Yeah, welcome
So
to
when
Canada.
does the emergency end? I mean, a lot of this argument has been about Congress's failure to act. 2 years from now, do we have any reason to think that COVID will be gone or that new variants might not be emerging? And when must OSHA actually resort to its regular authority and go through notice and comment, and not simply be kind of doing it in this quick way, which doesn't afford people the voice in the process that they're otherwise entitled to?
So I think if I could respond to that in a few different ways. Congress defined when the emergency exists. It labeled this an emergency temporary standard, but it's dictated by the statutory requirements. So there has to be a grave danger from a physically harmful agent or a new hazard, and the measures have to be necessary to protect against that danger. And we don't think that there's an additional free-floating requirement about emergency status that has to be taken into account.
So it could be an emergency 2 more years
Forever.
from now.
Well, I certainly take the point that the emergency can be of substantial duration. Of course, this is not a way to bypass notice and comment permanently. Congress further specified that the agency
seems like it is
to conduct a rulemaking process over 6 months, and that's why the agency estimated the lives saved, the hospitalizations prevented over the 6-month life of the rule.
Sure, but I was envisioning a new rule, right? Like, you know, OSHA might 2 years from now adopt something that's different from this vaccine or mask and test mandate. I'm just talking about the limits more generally on OSHA's power under the.
And they just keep doing new
The limits,
emergency
I think,
rules
are the
every
ones written into the statute, and so
The
if you want
emergency was not meant to be
project out
ended,
2
Robert.
years
It was
from
meant to
now,
be
I think it's
permanent.
entirely possible, of course, that the trajectory of the pandemic will change. I certainly hope so. And in that case, OSHA, I think, would have to, if it wanted to regulate again, cross the high burden of showing a grave danger. You know, this is an authority it has used sparingly in cases of what we think are true emergencies. And I think to suggest, based on concern about what might happen in the future, that its authority should be constrained or clipped now when we are in the middle of an unprecedented pandemic that is claiming
How many
more
times
lives
that
than we've
they
seen
said
in a
it?
shorter
In the middle
amount
of
of
an
time
unprecedented
would do
pandemic.
a
Can they play
disservice to
Fauci?
I mean, this is not an
the
unprecedented
that
pandemic. This
OSHA might need
pandemic
to
doesn't even
actively
come
respond
close to the
dangers
Spanish
like
flu.
this.
Doesn't come
Thank you.
close. And that happened in the last
Mr.
century.
Keller, rebuttal?
So it's just
Can they get to Fauci saying that they're overcounting hospitalizations now to talk about this unprecedented
2 points,
pandemic?
Mr. Chief Justice. First, we need a stay now before enforcement starts. Our members have to submit publicly their plans to how to comply with this regulatory behemoth on Monday. Vaccines would need to occur by February 9th. You would need 2 vaccines to comply. Those vaccines would have to start immediately. Tracking and record keeping cannot happen overnight. And
this
on
is where
tests,
Sotomayor was
my
lying
friend, the
earlier.
Solicitor General
She was saying,
mentioned
"Oh,
media
you
reports
can,
that we've all
nothing happens
seen
until
about
February,
shortages
right?"
of tests and cost
No, because the
increasing. Our
vaccines require a
declarations,
month in
appendix
advance
page
to start
345 and 374 confirm that as well. And that's exactly why workers will quit right away. You don't even have to take our word for it. The federal government, the Postal Service, and Amtrak both say the same things. What OSHA did is they cherry-picked one study about healthcare workers, a very specific industry, and what that worker attrition rate would be. Again, 2 declaration sites. We have plenty more, but appendix pages 351 and 374. And my second point to close on is about who decides in the public interest. And I would submit that this court's precedents answer that. We're not asking this court to reverse anything. Industrial Union 40 years ago, in Justice Stevens's controlling opinion, said that there was an absence of a clear mandate in the OSHA Act. So it's unreasonable to assume that Congress gave OSHA unprecedented power over American industry, and the emergency power is also narrowly circumscribed. Yet here OSHA has never before done mandated vaccines or widespread testing, much less over all industries or on an emergency basis. So whether we're talking about the agency's failure to explain, whether we're talking about the statutory term necessary, whether we're talking about how this has to be tethered to the workplace under the major questions doctrine, under any one of those theories, we are likely to succeed on the merits. And finally, when it comes to the public interest, as this court just recognized a few months ago, it is undisputable that the public has a strong interest in combating the spread of the COVID-19 Delta variant, but our system does not permit agencies to act unlawfully, even in pursuit of desirable ends. We would respectfully request a stay of this unprecedented sweeping ETS before Monday.
Thank you, counsel. The applications are submitted.
All right. Now we go to the Medicare mandate. I'll be right back.
Oh, yeah, people. I've got all the stream to myself. Well, in Quebec, for everyone who, how did I just take up the whole screen? I didn't even do that. I'll kill some time and tell you what is in the future for America. You can see it from the bellwether of Canada. I believe as of January 18th, the booster is going to be required in order to be considered fully vaccinated. And apparently, they're going to require vaccine passports for even more places than they have been requiring them up to now, because 80+% of Quebec is fully vaccinated. And that's not enough. It was 70% open back up. Now we're at 80+%, and it's shutting things back down and going after the sub 20% who are not boosted, to say they're the reason why. Not vaccinated, not no, sorry. The sub 20% are not fully vaccinated. The 80% who don't get boosted as of 2 weeks from now will now be among the unclean. So yeah, that's where things go. What's amazing is that this has been transformed into a 2 weeks to flatten the curve to a literal war on the unvaccinated, as if they are the ones to blame for the current spread of cases. It's an amazing transformation. If you want to study how you mold, how you transform, how you manipulate social trends, this is it. It starts off with the small nudge, what we call scope creep in the industry. You know, oh, I need you to do this, and now I need you to do this, and now I need you to do this. And when you're a lawyer, and it starts off, I just 5-minute question, you know, just answer me. And it's like, oh yeah, okay, but that's the answer. But here's a little more information. It's like, oh, but now I need you to prepare this document. And then lo and behold, you're 6 hours in, and you don't even have a confirmed mandate yet. That's how people get screwed, and that's how they don't get paid at the end of the day. But 2 weeks to flatten the curve, 2 months to flatten the curve. Put on your face mask, you know, do it voluntarily. Then it becomes mandatory. Socially distance voluntarily. Then it becomes mandatory. Vaccinate voluntarily, then it becomes mandatory. Vaccinate twice voluntarily, then it becomes mandatory. And then even the double vaccinated who have given up everything, like Barnes said at Tim Pool's party after our podcast, if you don't own your body, you own nothing. After you've given your body up to the government, they come back next, and say, you're not fully vaccinated unless you get boosted.
Biden, President of the United States versus
Missouri. Rant over, people, but look what's going on in Canada if you want to see what's trickling down south.
Thank you, Mr. Chief Justice, and may it please the court. Hospitals, nursing homes.
Okay, we're to the second case now. Finally,
are you bringing in everybody else for the stream here?
Well, I have a separate stream, and they're sitting on it. So I'm not. I guess I could bring him here. I'm not sure what would be the right way to do it because that one's already out. You know what? I should go to the other stream and do a little bit of
workers from infecting their patients.
I could put this stream inside of the other stream.
He also found that any delay.
Exception. I didn't get the StreamYard link, so I can't bring up the chat. Can you bring up Sexy Lillers?
Preliminary
it's
injunctions
an orange avatar with an S in it.
Are delaying that urgently
it says, and it starts with Viva. I am unvaccinated in Quebec.
In half the country.
Oh Jesus, dude!
This court should stay those injunctions for two reasons.
Where is it?
First, requiring medical staff.
See, I make him an admin, and I get this.
Squarely within the Secretary's
if I'm off on the dates, it says Viva, I am unvaccinated in Quebec, but that's not true. Dubé specifically said that they would give months before the 3 vax pass would take effect.
The spread of infectious disease. Many healthcare workers are already required to be vaccinated.
Whether it's 3 months away or January 18th away,
measles, and flu.
When they're talking about vaccine passports to enter liquor stores and marijuana shops,
vaccination requirements.
And then it's going to be 3-dose compliant. I mean, if it's January 18th or March 18th, it's the same outcome. So if I got the dates wrong, forgive me.
Second,
but
the Secretary's
nothing else changed. It just gives you more time to leave if you want to leave this.
Do not seriously deny that
prison of
requiring
a
vaccination will save lives. Instead, they predict that it will cause staffing shortages.
Yes, this is true, Nevin Roth.
But the Secretary carefully considered that concern. He explained that experience from around the country shows that most workers actually will choose to be vaccinated rather than to leave their jobs in response to vaccination requirements. And he concluded that the risk of some temporary staffing shortages is outweighed by the urgent need to protect all Medicare and Medicaid patients during a deadly pandemic. Congress assigned those quintessential predictive and policy judgments to the Secretary, and the states have identified no basis to disturb his conclusions. I'd welcome the court's questions.
Counsel, are you relying on 1302A?
The Secretary invoked, that's the Secretary's general rulemaking authority under the Social Security Act, and he invoked that general rulemaking authority as he typically does when he makes rules under the Act, but we're not relying primarily or on that. We're instead relying on specific authorities as to each category of covered providers that allow the Secretary to set standards that set the requirements for their participation in Medicare and Medicaid.
Performance standards.
I don't understand what you just said.
The answer is yes, but not only on 1302. We also have specific statutes that speak to each of the covered.
So if I look at the language in 1302, which says that the Secretary shall make and publish such rules and regulations as may be necessary to the efficient administration of the functions with which each.
We lost it.
Well, Eric screwed something up. And anybody, to repeat what Eric said, if anybody wants to just hear the stream with no commentary, Eric put the links in the chat. If you just want to see two beautiful faces and listen to audio.
I got to hop off anyway. I got most for the takeaway for people out there is I'm sticking with my original opinion. It'll be 5463, but that the OSHA mandate and Medicare mandates, contractor mandates will all fail. That the Supreme Court will, in fact, step in and stop them. The only question is whether they do it now or they do it a month from now. But I think they're going to do it now. And that's, it's clear that Barrett and Kavanaugh and Roberts are the undecided. The 3 liberals are for it. The 3 conservatives are against it. The 3 so-called centrists, whatever you want to call them, Barrett, Kavanaugh seem pretty strongly against it. So I think Kavanaugh is clearly a 4th vote with the conservatives. And the only question is, do you get either Roberts or Barrett? And I'm still betting that you get both because of the problem. This was too much, too fast. And that's what even Breyer was pointing out. And he was trying to get the Solicitor General for the government to come in and say, hey, here's why this isn't too fast, too broad. And she didn't. She really was not well prepared today. I think the independent business people did well. I think the representatives of the states did well, particularly in the reply. It's always good when you have the last word to just give them, here's 3 points in reply, 1 minute reserved, that kind of thing to hammer home. And I thought the points hammered home were good. It was good to see Alito raise questions about the efficacy of the vaccines. Good to see Thomas raise questions about you're really just trying to force employees. This is the first employment standard in history where you're trying to force employees to protect themselves from themselves. That's what's. I mean, this was supposed to be about regulating employers, making sure things are safe for employees, not regulating employees for themselves. But they clearly a lot of the judges buy into the general assumptions about this vaccine that I think are unwarranted. But it shows you how much the professional class is scared of being labeled anti-vaxxer, that even Alito has to go on a long thing about, I'm not an anti-vaxxer, I promise. But, there's unusual risks here in that most employer mandates don't impose a risk on the employee. They're supposed to reduce risk for the employee. So I'm still sticking with by Monday, a 5-4, 6-3 decision that stays the mandate.
I was getting texts from nervous friends who think that this is not looking good for the states. But you imagine the argument was that this is necessary because if it's just a personal choice issue, that would be the choice of the employees. If the vaccine works for the vaccinated and reduces symptoms, that fine, they've already gotten vaccinated. But they need to implement this to protect the unvaccinated who can't get vaccinated from the unvaccinated who choose not to get vaccinated. And anyone can, you can crunch the numbers to figure out how astronomically low.
No limitations by age, by industry, by workforce, none of that. And so I think, even Breyer voiced I think he wasn't really voicing doubts. He was trying to get the Solicitor General to give a good counter argument to Roberts. But the key that mattered is, one, more questions were asked to a certain, I think ultimately from enough justices, more questions were asked of the state than were asked of the people challenging the feds. And generally speaking, whoever gets more questions loses. And so that's, Kavanaugh asked more questions of the government. Barrett asked more questions of the government. Roberts even ended up asking more questions of the government. So that's usually a sign that's where they're going. They're going against the government by asking that number of questions. And all that mattered is, were there two of it's. Gorsuch. Nothing Gorsuch said suggests anything different than he's going to say this is not legal. Nothing. Same with Alito. Same with Thomas. And the only question was Kavanaugh and Roberts and Barrett. And Kavanaugh's questions were almost all hostile to the government's position. And he was, teasing out what the arguments were in opposition to his argument, but that was kind of clear what he was saying. Barrett, for the most part, was the same way, though she was trying to limit the scope of the ruling. And Roberts, the same way, though he too was trying to limit the scope of the ruling. But they said that they inclined more towards striking this down than affirming it. So that's why I think you only need 5 votes. I think they may even get 6.
Now, I missed the answer, but what was the answer for the obvious question? Why doesn't Congress just do what you're trying to do through OSHA now?
Oh, because the fact that Congress hasn't means that Congress doesn't agree. Now, what was interesting is nobody raised the fact that the Senate had said they oppose all these mandates. A majority of the senators voted that way. So everybody knows why Congress hasn't done it. Now, I would have liked it if they would have pointed that out. But in the argument, there were some arguments I thought they left on the table in terms of the efficacy of the vaccines, the redefinition of this from a vaccine, the unique risk it imposed on individuals. But what was fascinating was how much this was a policy debate rather than a legal debate. The focus, Barrett's questions were almost entirely legal oriented, as were Kavanaugh's and to some degree Roberts. Almost every question from Breyer, Sotomayor, and Kagan were
in healthcare settings
entirely based on policy. But I got to hop off here.
Okay, go for it. And Eric asked me to bring up the audio, but I'm worse technologically than Barnes. So Robert, see you Sunday.
Oh wait, now I'm thinking everybody should jump over to the other. My head hurts.
And as we explained,
people, the crowd is here bringing the people.
All right, hi, Alita. Welcome to my.
I'm just taking Barnes' place.
So I don't
apparently
any of that, but in making all of those points, I don't want to undersell also everything you heard about.
So where are we right now in the oral argument?
The pandemic poses for workers.
They just started the second one, I think.
Medicare, Medicaid.
Okay, got it.
Counsel, there is another significant difference that you haven't talked about. This is a spending clause case. and not a general powers case. And I always thought that when you're talking about spending clause, that the government has more power to define where it wants to spend its money, correct?
Absolutely.
And to that extent, one of the major arguments raised by the other side here that I want you to address is what they describe as the enormous cost.
All right, everybody, there's a ton of confusion. The chat's going nuts.
And the fact that
I had two streams overlapping, and it caused some major confusion.
Could you please tell me whether this is unprecedented in terms of what CMS generally does?
I can, and first, if I could, I'd like to put in context the cost. I think the Secretary's cost estimate was on the order of $1.3 billion, much of which will be borne by the federal government, which covers the cost of vaccinations. He put that in context by emphasizing that healthcare spending in this country is $4 trillion, and that the costs in this case amount to about $125 per employee. So I don't think the costs of this rule, when viewed in context, are particularly great. And I think that it is not at all unprecedented for the Secretary to exercise the same authorities that I was discussing with Justice Thomas here, the authorities to set conditions of participation for hospitals and other providers in Medicare and Medicaid, to impose very detailed, very prescriptive requirements that would have very high compliance costs. This is not a place where it's unfamiliar to have the Secretary involved in the details of the management of healthcare organizations.
Did the states have clear notice that by accepting Medicaid funds, they would be subject to vaccination requirements for staff at their state-run facilities?
So the facilities, and this applies to all facilities in Medicaid and Medicare, not to the states as the administrators of their own Medicaid programs, but I acknowledge states do have state-run facilities. All of them are on notice that they're subject to the health and safety requirements that the Secretary may adopt from time to time. Obviously, they didn't have specific notice of the vaccination requirement because it didn't exist until the pandemic came about, but the way that the program operates is that all providers are on notice that they have to comply with the Secretary's regulations, which could change.
So if they read the statutes that you are now relying on primarily, that would provide them clear notice that they might be subject to something like this vaccination requirement?
It would put them on clear notice that they are subject to such requirements as the Secretary finds necessary in the interests of patient health and safety, which have long included infection control. In the past, that's been general. It's been requiring infection control plans that meet national guidelines, fire preparedness, emergency safety, things of that nature. So they have long been on notice that they are subject to requirements by the Secretary in the interest of patient health and safety. And I think this is a sort of heartland case of a measure to protect patient health and safety in the midst of a pandemic.
I don't have before me the particular statutory provision that you spoke of earlier, but is it the case that some of many, if not all, of these additional statutory provisions on which you are now placing your principal reliance are definitional provisions rather than provisions that expressly authorize the Secretary to promulgate regulations? Is that correct or incorrect?
They're both. So they are definitions. The provision I quoted earlier, 1395 XE, is the definition of a hospital for purposes of the statute.
Right.
But in that definition, it says a hospital, and what it means to be a hospital is to be eligible for Medicare reimbursement. What it means to be a hospital is to meet the following specified requirements, including such other requirements as the Secretary finds necessary. So,
right. But it doesn't say the Secretary is authorized to promulgate any regulations that protect the health and welfare of people in a hospital or in any of these other facilities. It says that the definition of a hospital and the definitions of these other facilities, by definition, they are facilities that are required to comply with regulations.
As the Secretary finds necessary in the interest of patient health and safety, yes.
Is there any limit to that power? What could the Secretary, what, if anything, could the Secretary not do if the Secretary finds that something is necessary to protect the health and safety of people in those facilities?
Well, I think the Secretary, the major limit is the one in the text of the statute itself. The Secretary has to find that it's a requirement that's in the interests of patient health and safety, as the Secretary did here. I think the other constraints on that authority are the types of health and safety measures that you see in healthcare providers. So, and the way you know that this provision is within the Secretary's authority is that you see providers adopting it on their own. You see medical societies like the American Hospital Association, the AMA, the American Nurses Association recommending the this policy. You see some states adopting this policy. I think all of those things are powerful confirmations that this is a routine, common, effective measure for protecting patient health and safety.
One of the arguments on the other side is that you were required by statute to consult with the states before you did this. What is your response to that?
There is a provision of the statute that says that when the secretary sets conditions of participation for some of the providers at issue here, in carrying out that function, he shall consult with the states. The statute doesn't say that that consultation has to happen before rulemaking, and the way that the secretary has understood that to function is to require consultation in conjunction with the notice and comment process.
Isn't that an odd understanding of a consultation requirement? We're going to tell you to do something, and then after we've told you to do it, we're going to consult with you about what we've already said you have to do.
You shall do it. You must do it. But you can do it after you've already done what you want to do.
Provisions of the statute that also contemplate, as the APA does, that in some circumstances the secretary will have good cause to act without notice and comment. So in the ordinary case, there's going to be notice and public comment, which has the benefits that Justice Barrett referred to earlier. When that happens, you should also be sure you consult with the states and with accrediting boards. But when there's good cause to skip that, the agency has long interpreted that to mean that it can
Joe, good logic. Check your DMs.
To the parallel public comment process.
Is there a good cause?
What was the good reason to skip the notes and comments?
Consultation.
There isn't
no
temporal requirement at all. So it's actually the other side that's asking you to read into that a requirement that had happened before rulemaking, and to make that requirement apply even when the good cause exception is satisfied. And we don't think there's any basis to do that. Certainly not in the secretary's past practice. This has long been the way that the secretary has interpreted this provision in conjunction with the good cause exception to notice and comment.
Mr. Fletcher, can I follow up on the questions that Justice Thomas and Justice Alito have been asking about the facility-specific statutes? I think it was wise to shift your focus to those because of their references to health and safety. But I find it difficult because the language of each of those statutes is different, and not all of them reference health and safety. So, for example, I think the one on long-term care facilities is your best, because that's the one that also refers to or requires skilled nursing facilities to establish and maintain an infection control program. That one, I think, gives you a stronger case than the ones that don't mention health and safety at all. Or, for example, for ambulatory surgical centers, the provision on which you rely describes the benefits provided to an individual, and then it lists
what I said before is that they shall consult,
covered, right?
And his argument was that they can consult after they've already done what they want to do. So the shall is obligatory, but you can do it afterwards, not before, which might undermine the reason for consulting.
A heavier lift to say that that kind of aside in a parenthetical is a grant of authority to CMS to impose this kind of vaccination requirement on those who work at the ambulatory surgical center. So I guess my question is this. One,
I can't turn up the volume of the feed
here
anymore,
seeking
guys.
The stay of the injunction.
All you can do, I guess, is turn us down,
right,
so that the balance is
I
the same.
understand because of space limits and the number of statutes on which you're now relying, it would be hard to make the specific case for each of these provisions. But what if
I can
think
try a
some of the
different
provisions
scheme.
might support you and others don't? This was an omnibus rule, and even though the secretary in a chart identified all these, specific provisions, we don't really have before us the structural and textual arguments directed at each of these provisions. So what if I think some do and some don't? In an omnibus rule, what am I supposed to do?
Well, so we agree entirely that the focus ought to be on the statutory text, and one of our complaints with the district court decisions in these cases is that they blew past all of those distinctions and didn't focus on the text at all. So we absolutely agree the text of these provisions should be the court's focus. In terms of how to think about them, I understand it's unwieldy. There are 15 different provisions. I would group them into two categories. There are 11 or so that we cite at pages 5 to 6 of our reply brief that include that specific health and safety language in different formulations, but all of them.
All right, guys, bear with me. I'm going to change it to the PBS stream and see if I can get that to be louder.
And as we've explained, we think that this.
Did he explain why they skipped out that step of consulting with states?
Agree the text of these provisions should be the court's focus. In terms of how to think about them, I understand it's unwieldy. There are 15 different provisions. I would group them into two categories. There are 11 or so that we cite at pages 5 to 6 of our reply brief that include that specific health and safety language in different formulations, but all of them specifically referring to requirements in the interests of patient health and safety. And as we've explained, we think that this is the paradigmatic health and
closed
safety
captioning, which might
regulation,
help.
and that's reinforced by the consensus of the medical community, by other regulators, by
Now
practices
it's too
of
loud.
providers.
Jeez, come on,
Now,
guys.
there are a few statutes that we
Just
cite
turn
at
it down
page
then.
9 of our reply brief that don't include that specific language. Those statutes are the ones applicable to providers that employ about 3% of all of the workers covered by the rule. Now, our view is that all of those statutes still give the Secretary the authority to set standards or requirements for participating providers. And if you look at those provisions, what you find is that Congress was a little bit less detailed. In the hospital provision, the 1395XE9, the preceding 8 sections all detail relatively nuanced, very specific requirements for hospitals. And then the E9 adds, and such other requirements as may be necessary.
But what if I disagree? So I understand that your position is that all of these granted the Secretary authority. But what if I disagree? What if I say, for example, you suggested in a footnote in your reply brief
Come
that
on,
because
guys.
such a small
Like I have the
percentage
control over
of
YouTube and everything
employees
else.
are covered by the statutes that don't reference health and safety.
Well, you could
that
lower
we
the
should
volume
just,
on that. You can play YouTube a
allow
little lower.
the injunction
Yeah,
to
I
remain
did.
in place only as to
I'll do a little
those.
bit more.
And let's say that I disagree with you that every single one of the statutes that references health and safety could be interpreted as a
All right.
grant of rulemaking
Now I'm
authority
talking,
for the reason
and
I
they're talking.
suggested with
How's
ambulatory
the volume?
surgical centers.
It's good.
I think
The
it's fine.
rule is an omnibus
Good.
rule. You know, it wasn't adopted on a facility by facility basis. So if I assume the premise that I disagree with you that every single statute grants this authority, why shouldn't then we just leave the Fifth Circuit's injunction in place?
Well, because I think to the extent you're looking at likelihood of success, that's the factor that this would be relevant to. I think that does depend, as you say, on the authorities as to each category of providers. And the Secretary included, in some sense, it's an omnibus regulation. He did it all at once, but he included specific severability language that we cite in that footnote. It's at page 61,608 and said if any of these provisions are no good, then the rest ought to stand. And so I think if you disagree with us on either the provisions that lack health and safety language, or if you disagree with us on the ones that have it, although I want to talk about both of those things to hopefully persuade you otherwise, I think the result would be we don't have a likelihood of success at obtaining prevailing on those provisions. But that wouldn't justify allowing the injunctions to remain in place as to all of the other provisions, especially those that cover the vast majority of workers. So I think that's the approach we'd suggest if that's where you find yourself.
Mr. Fletcher, I do understand that we could go provision by provision, but I thought in reading your brief that the general authority to pass regulations to with respect to the Secretary's functions, that all that you were saying is that generalized authority is well documented by the fact that in the vast majority of these, at least 11, if not 12, of these specific rules, they reference health and safety directly. Isn't that your point?
That's our point, and in addition, that
loaded
even as to
question
the
from a
ones
judge.
that don't reference health and
Well,
safety, so
yeah.
the end-stage renal disease providers or the psychiatric residential treatment facilities,
Just trying to
those
sort of
categories,
lob one
Justice
over the net
Barrett
for him.
and Justice Sotomayor, they still give the Secretary even broader authority to set conditions for participation. And our view is that when the Secretary is authorized to set conditions for participation in Medicare and Medicaid, that has to include the authority to set patient health and safety requirements. And in fact, that's the way the Secretary has long interpreted them. If you look at the regulations that are being amended by the provisions addressing those categories of providers, they're existing bodies of patient health and safety measures, in many cases addressing infection control already, in other cases addressing other matters directed at patient health and safety. So the Secretary has long interpreted those more general grants of authority to include the authority to impose patient health and safety conditions, and we think that's the right way to read them in the context of the statute.
I dare say that I looked at some of the regulations at issue here, not the ones you passed with respect to COVID, but the other regulations. Is it fair to say that the vast majority of the regulations across all facilities relate to health and safety?
Is
I
it
think
fair to
that's
say?
fair, yes. That's certainly
Loaded question.
consistent with my reading of the regulations
It's-
applicable to the facility providers at issue here.
It does
It's a
seem
leading
that,
question. She may as well just tell them what to
since
say.
it's a program to serve ill people with conditions like renal failure, psychiatric conditions, other conditions, that would be the primary focus of contracting with places that are safe for those people, correct?
Absolutely, and
They
that's the way
basically
the
have two
Secretary has
attorneys
always
up there.
understood those more general authorities.
Well, I mean,
Thank
this
you.
always happens in any kind of oral argument, right?
If I could
you
say just a
generally
word
have
about
some
the other
justices
argument
that are
that
going
the
to be
other side has
supportive,
pressed
some that
heavily in
aren't.
this case, and
And
that's
so
the
they'll
concern about
ask some
staffing
supportive
shortages.
questions to sort of help
That
them
is a concern
help
that the
them
Secretary
bolster their
acknowledged
argument.
and considered in
If
the
that were a
regulation.
question asked by a
And he
lawyer of
explained
his or her client, it
nonetheless
would be
that he was
objected
adopting
to
a
as a
vaccination
leading
requirement
question.
for
Of course,
several
but
reasons.
this isn't a
First, he
a
explained that
trial court.
experience from
No, but this is
around
where
the
people are
country
going to say
has
these
shown
judges are
that
activists on the
even
bench.
workers
That's where the
who
accusations are
express
going to come from.
hesitancy or even strong objections to becoming
Well, as
vaccinated
Barnes pointed out,
don't
they're arguing
actually
with
end up
each other
losing their
through the
jobs in
questions.
those large numbers when vaccination requirements
Exactly.
are imposed.
They're basically
when their
giving
employers can help
themselves
facilitate
ammunition
vaccination,
for
can counsel
their
them,
arguments
that across the
backstage,
economy, including in the
and then
healthcare
also
sector,
in
including in
their
rural
eventual
areas, including
opinions.
healthcare systems in North Carolina and Indiana, the
And
Secretary
that's why it's
found that
helpful to
vaccination requirements
it's
achieved
helpful
very
to
high
listen to
levels of
to this so we
compliance.
can sort
He
of get a
sought
feel like,
comment on
okay,
the
we know
issue,
Sotomayor
sort of welcomed input
is
from
gonna knock down the
stakeholders
injunction.
about the particular challenges faced
Which,
by
I
rural
mean,
hospitals.
you could probably guess
But
that,
he also
generally
explained
speaking,
that any
based
temporary
on
staffing
how she's come
shortages are
across in
likely to
other
be
opinions
relatively
and
minor
other
in the
writings that she's
context
had
of this
before.
industry,
100%.
which
But
already faces
that's why the key
enormous
questions
staff
come from
turnover
Kavanaugh
every
and
year.
Barrett,
He said the rate of staff
Gorsuch,
turnover in the healthcare
Roberts,
industry generally
Yeah.
because
is
that
about
way you get a feel for where they're
25%.
at.
Yeah,
in normal
I would
conditions,
say
and that
Gorsuch
in those
and Roberts are
circumstances,
probably
any
the ones
marginal additional
that
turnover
I
attributable
would want to
to the
most focus
vaccination
on, because they're
requirements
going to be the ones
does
that'll
not outweigh
be
the need to
the
impose this
tipping
health and
points,
safety
generally
measure
speaking.
that, again, is supported by the medical community and has already been adopted by providers around the country.
Thank you, counsel. Justice Thomas, Justice Breyer, anything further? Justice Alito? Justice Kagan?
Wow.
Mr. Fletcher, the states
Who is this, Justice?
talk quite a bit
Kagan.
about
Kagan.
the time that it took the administration to get out the good cause rule and suggest that in that amount of time, it could have done a full notice and comment proceeding. I guess I would like you to comment on that. Is that true?
It's not, for a number of reasons. I think the clearest is the provision governing notice and comment regulations that applies when good cause isn't found for the secretary. 1395 HH says that the secretary has to allow a 60-day comment period. So that right there is more than 2 months. In addition to that, the secretary has to write the rule, which involves not just developing the regulation and fitting it into the existing conditions of participation for 15 different categories of providers, but also writing the sort of detailed cost-benefit analysis and paperwork Reduction Act analysis that are required by statutes and executive orders and that occupy dozens of pages at the back end of the rule. So I think the suggestion that in 2 months the agency could have completed notice and comment rulemaking is inconsistent with both the applicable legal requirements and just experience with regulatory process more generally.
We can't go fast enough, so let's cut the
An ordinary
points.
person might say, well,
Cut
it's
your
really
rights.
important. Why don't you just work faster?
I understand that. I mean, that doesn't get you around the 60-day time limit. And what I can tell you is that the secretary did work extremely fast, produced a 73-page rule in 2 months, and explained why the rule was necessary, satisfied all of the legal requirements. And I think, I don't want to fault my friends on the other side, but I think if the secretary had rushed something out with a less thorough explanation, I think we'd be hearing legal challenges that he hadn't adequately explained things or considered things or calculated out the cost benefits. I think agencies that are trying to make policies that will stick have to make sure that they engage in the kind of robust analysis and document that analysis in the way that the secretary did here.
Justice Sotomayor? Anything further? Come back to you. Justice Gorsuch?
This statute, unlike the OSHA statute, actually contains an express limitation on the secretary's authority that we haven't yet discussed and that I know you're familiar with. Among other things, it says, the secretary shall not control the tenure of employees at covered healthcare facilities, or their compensation or their selection. And this regulation, arguably, the other side will say, I'm sure we're going to hear it, so I didn't want to hear you have a chance. It's going to say this effectively controls the employment of individuals at these healthcare facilities in a way that Congress specifically prohibited. As I understand your response, it is we're just providing money or not providing money. And by withholding money, we're not controlling who you hire. And I might understand that in some circumstances, but in a statute where everything is about spending, it's a spending clause statute, I would have thought that Congress would have understood, and we should interpret this language in that light, that you cannot use the money as a weapon to control these things. And in fact, of course, as you know, the court has some anti-commandeering law. That's doctrinal speak for you can't always use money and claim you're not controlling what's going on. And I wonder whether we should take particular cognizance of that here, given that these statutes sometimes constitute, we're told, 10% of all the funding state governments receive. This regulation affects, we're told, 10 million healthcare workers and will cost over $1 billion for employers to comply with. So what's your reaction to that? Why isn't this a regulation that effectively controls the employment and tenure of healthcare workers at hospitals, an issue Congress said the agency didn't have the authority? That should be left to the states to regulate.
So Justice Gorsuch, you're talking about Section 1395, and that says that nothing in the Medicaid Act shall be, or Medicare Act shall be interpreted to authorize any federal official to control, as you say, tenure, staffing, the practice of medicine, or the administration of entities. We read, as the Secretary has long read, that to mean that he can't dictate particular decisions. Hire this person, don't hire that person, treat this patient this way, not that way. That's what control and supervision means. And
can it mean, though? Could it mean? Should it mean? Have we in other cases interpreted similar language to mean you can't use money in a way that commandeers a state or private entity?
So
just happened with Biden in Texas.
The answer is that that's not, it can't mean that in this context, because you have to.
Could it mean it? And do you agree that it means that in other contexts?
Control and supervision can mean different things in different contexts, but I do want to get out that they have to mean something that's consistent.
But fine, I'll let you do it, I promise. But you'd agree that in some contexts, in some circumstances, that's a possible meaning.
I think it may be a possible meaning. I don't think it's the most natural reading.
All right, now you get to go ahead. Got it.
Thank you. I appreciate it. So the reason why it can't mean that here is that succeeding provisions of the Medicare statute authorize the Secretary to do, or actually do directly by Congress, exactly that sort of standard setting that the Secretary is engaged in here. So just take the hospital statute that we've talked about a bunch, 1396 XE. There's provisions, we talked about E9, which is health and safety. The preceding provisions say things like you have to be staffed by doctors, and the doctors have to have particular licenses. You have to have a certified nurse on duty 24 hours a day. You have to have a budget plan that meets the requirements of another subsection.
Okay, so that doesn't control, but somewhere along the line, you move from general regulations that outline things you, the hospital, have to do, to somewhere more directly where you are controlling or supervising. We agree?
Yes.
There's a sliding scale in there.
I'm not sure about sliding scale. I would say standard setting, we can tell from that context.
There's a range. Can we agree on that?
Sure.
Okay. Where's the line?
I think that as often the case with ranges, the line may be hard to draw when you get out towards more granular controls.
Gorsuch is the best addition by Trump. It's so not close.
Standard is on the right side of the line because it's consistent with standards in the statute itself that say you have to hire physicians and nurses that meet these qualifications, or with other provisions that say you have to train, your staff must be trained in this way.
I understand that. What do we do about the fact that Congress has never, that CMS, not Congress, we don't have Congress here, CMS has never before said among its standards a vaccination requirement or any other health standard with respect to employees and actions they must take outside the work environment. So, for example, could CMS also implement regulations about exercise regimes, sleep habits, medicines and supplements that must be ingested by hospital employees in the name of health and safety? And would the government argue that does not control the tenure of those employees?
I'm not sure that there'd be a problem with those requirements. I don't think it would be the Section 1395 control. I think it would be that it's very hard to characterize those as requirements for the health and safety of patients.
But in your view, that would not control the tenure of employees?
I think that does not. Setting standards, even if they're outlandish standards that we think couldn't be set for other reasons, wouldn't be controlled.
Still doesn't control. Doesn't control, even though they have to take these medications, they have to get this much sleep, they have to do this much exercise every day.
Again, I want to be clear. I'm not suggesting the Secretary can do any of those things. I'm just suggesting that the reason he can't is not 1395.
Because it doesn't constitute control of an employee's tenure or compensation.
Correct, because setting standards for employees does not exercise control.
Justice Kavanaugh?
You mentioned at the beginning that the over $1 billion in costs would be borne mostly by the federal government, I think you said. Can you explain that?
Sure. I think in large part by the federal government. So the secretary, in estimating the cost, said a big driver of the cost was going to be the cost of the vaccinations themselves, the shots, and the cost of administering the shots. The secretary explained that he was including that in the cost-benefit analysis to be comprehensive about the effects of the rule, even though the federal government covers the costs of vaccines for most employees and would cover them here.
Okay. And then on the question, to follow up on Justice Gorsuch's question, what is the story, as you understand it, for why CMS has not previously required flu shots for healthcare workers or some of the other vaccines that, as you pointed out, the states still insist upon for healthcare workers? Is there a story there, or explanation there for why CMS has not previously done that?
I think the secretary laid this out and sort of identified different reasons as to different categories of vaccines. So as to some where state vaccination requirements mean that everyone is basically vaccinated against those diseases already, there was no need for the secretary to do that. The secretary also hasn't acted with respect to flu vaccines. Some states have done that. Not every state has done that. But the secretary explained that this is a pandemic that is a much graver threat than the seasonal flu is. And also that these are uniquely effective vaccines. And
uniquely effective
vaccines. Okay. Unique situation that we haven't seen before.
How many times have we heard grave threat today?
Well, someone think of the children, Eric, please.
Thank you.
Justice Barrett?
Will someone think of the
Are you
children?
arguing with respect to the facility-specific grants? And this goes back to the questions that Justice Sotomayor asked you after we last talked. Are you arguing that those facility-specific grants inform the general grants in 1302A and 1395HH, such that we should interpret the general grants as encompassing the authority to impose health and safety measures? Or are you arguing that even if we pretend that these two general grants don't exist, that the facility-specific grants would nonetheless equip the secretary with this authority?
I think the latter. I think I'd be making the same argument even if we didn't have the general grant. I think the general grant, reinforces the idea that when the secretary sets standards, he has the power to do that through regulations, but we're relying primarily on the specific grants, and I think those would be sufficient even if you set aside 1302.
Thank you.
Thank you, counsel.
That's it? Oh, that's one side. I'm sorry. Okay. They seem bored here. They seem less interested.
Mr. Chief Justice, and may it please the court. In
early
2020,
the
while
same
millions stayed
as
at
any
home,
other SCOTUS.
millions of
No, but the
healthcare
last
workers
one, they were
heroically
going
stayed
for
at
2
work.
hours. I think
These
they're
same
much more
workers are now
interested.
forced to choose between losing their jobs
When did this
and
start?
complying with the government's vaccine mandate.
This is the second argument started about
Secretary's claim of authority
half hour
to impose
ago,
this mandate
20
is
minutes ago.
expansive,
First one went like 2 hours and 20 minutes.
and unlawful for two principal reasons. First, the Secretary believes a series of vague catch-all provisions scattered throughout the Social Security Act authorize the sweeping mandate, but the relevant text, structure, and context say otherwise. For example, the Secretary ignores 8 provisions that precede the catch-all provision he primarily invokes, all of which are materially unlike a permanent medical procedure that cannot be undone after a shift is over. Exceedingly clear language is required here because the mandate regulates matters that have traditionally been within the province of the states. Second, the rule is arbitrary and capricious under the APA. The Secretary impermissibly extrapolated evidence for one category of facilities to justify regulating all 15, and failed to adequately explain his sudden shift from encouraging vaccination to mandating it. But more fundamentally, the Secretary overlooked the critical perspective of rural healthcare facilities in the states and the devastating consequences the mandate will have on rural Americans' access to healthcare. Categorically excluding an entire class from employment will mean that patients in rural Nebraska will have to seek primary and emergency care 2 to 3 hours away and cannot undergo surgery. This represents vast stretches of this country where healthcare is not provided by massive institutional providers with tens of thousands of employees, but by smaller healthcare facilities run by local communities. While a 1% loss of staff may be insignificant to the former, it is fatal to the latter. Without the injunction, rural America will face an imminent crisis. The government stay application should be denied.
I may have to duck out soon,
I
people.
welcome the court's questions.
They found me.
Counsel, would you discuss the preemption issue just briefly?
Yes, Your Honor. This regulation, the Secretary says in this regulation that it is intended to preempt arguably any inconsistent state laws with respect to vaccination requirements. And for example, in this case, the most direct example I can point to, Your Honor, is at 20-7-134 of the Arkansas Code that prohibits as a condition of employment any sort of vaccination requirement.
But that's
Ladies and gentlemen,
somewhat ironic.
I have to duck out. I'll do my best to get back in.
The government relies on those other vaccinations to argue for this vaccination. But are all of the party states in the same position with respect to preemption?
Your Honor, certainly the district court in this case, at the very least, cited that Arkansas, Wyoming, and Missouri are similarly situated with that respect. And certainly there are other states in the Missouri-led coalition that also have laws that are going to be preempted by this regulation. The key point here, Your Honor, just like in Mass VPA, is so long as one of us has one of these laws that would affect our duly enacted legislation through an unlawful mandate, it does present an issue on preemption. Now, that's independent, obviously, from other interests that the states have in this case, which is the states are the administrator. It's our providers with respect to Medicaid. With Medicare, we're being asked to facilitate this program for the federal government. We have compliance costs. We have surveyors who have to go out and enforce this rule. All of that are the state's interests, Your Honor.
Well, the one final point has to go to standing. You seem to rely on parens patriae a bit. And would you discuss that standing and why we should apply that?
Well, sure, Your Honor. And just to be clear, we do have various capacities here. We mentioned sovereign interest. We mentioned proprietary, a whole plethora of them. And certainly we did invoke also a quasi-sovereign interest in the health and well-being of our citizens. For example, this mandate will close the doors of many of these rural facilities that will effectively deprive our citizens of health care. And we also are asserting rights under federal law with respect to the APA on many of these claims. But that is not the only basis that we're seeking standing in this case. We have various other capacities that we're suing under, just like the ones I mentioned, Your Honor.
Is that true of all of the parties?
I believe so, Your Honor, yes.
Thank you.
There was a question. Sorry, Chief.
No, I was just going to ask you about the spending clause context. In other words, we're not just dealing with federal law in the abstract. We're dealing with a provision that says Congress authorized the Secretary to ensure compliance with requirements that the Secretary finds necessary in the interest of the health and safety of patients. That's very broad, and I think. Will you agree that they have broader authority because it's in a spending clause provision? I mean, you signed the contract.
Well, sure. And even in the spending clause, I would say two responses to that, Your Honor. First, even in the spending clause context, as Justice Alito mentioned earlier, the states are entitled to clear notice. So there is, whatever conditions the Secretary does state, they have to derive from unambiguous grants of statutory authority. And in this case, Your Honor, we respectfully disagree with my friend, Mr. Fletcher, because he only cites certain parts of these provisions. For example, with respect to the hospital in this application, he ignores the such other requirements language that precedes the Secretary's authority to regulate health and safety. And many of those provisions, for example, E1 through 8, none of those talk about immunization. They talk about record keeping. They talk about discharge procedures. They talk about
Mr. Rossetti, really, do you think that the CMS head and that the Secretary of HHS are bookkeepers with respect to this statute? Do you think that they don't have responsibility to protect the safety of these two incredibly vulnerable patient populations?
He's saying it's condition precedent to their authority.
Responsibility in these laws? Isn't that the most important thing that both of them do?
Your Honor, certainly the Secretary does have authority to set requirements in the interest of health and safety. All I'm saying is you have to look at the statute in context. I'm not saying that HHS is somehow just this record-keeping function. I mean, certainly it is important for these facilities to have adequate record-keeping. You're dealing with vital records, health records, other things.
I wasn't saying that they don't have to be concerned about records either. I'm just saying, in addition to being concerned about records, this statute clearly gives them, by reference to the health and safety delegations, by reference even to the idea of administering efficiently programs like this, their principal job is to look after the health and safety of Medicare and Medicaid recipients. And with the understanding that those two groups of patients are pretty much the most vulnerable patients there are, either elderly patients or in the case of Medicaid, unfortunately, poverty has a great deal to do with medical outcomes. So, with respect to these two vulnerable populations, and especially vulnerable when it comes to COVID, how can it not be the principal prime responsibility of the CMS head and the Secretary of HHS to look out for their health and safety?
Because that responsibility that falls in E9 with respect to the hospitals, which is what the Secretary has put forward in this application, that authority is informed, the grant of authority in that section is informed by the other provisions in that statute. Doubly so here, Your Honor, where you have a situation where this court has said that ordinarily compulsory vaccination is not something that ordinarily concerns the federal government. That was in Jacobson at page 38. Doubly so here, Your Honor, because when you're going to significantly alter the balance between state and federal power, something that has traditionally been in the province and the states, you have to do so with exceedingly clear language. The court said that in Alabama Realtors recently. The court said that also in U.S. Forests in 2020. That is the kind of language we're asking here. It's not that the Secretary...
Do you think that the Secretary can require the adoption of various infection prevention and control measures? Can they say to hospitals, you have to sterilize your instruments, you have to wash your hands in a certain way? One of the things we understand about settings like this one is the way that infections spread.
Sure.
And you have to do a variety of things to make sure that you prevent the spread of infection. Can they do that?
Your Honor, absolutely.
Because that's their job, right?
Your Honor, certainly with respect to 1395 I-3 D3, which goes to skilled nursing facilities, there's express language that the Secretary can adopt infection control measures to prevent the spread of
whether
disease.
there's express language of that kind or not, the responsibility to look after the health and safety of vulnerable populations includes requiring infection prevention and measures. Isn't that right?
Well, certainly, Your Honor, if Congress decided to write statutes in very express terms with respect to the skilled nursing facilities, and I will submit...
I think you're ignoring the question. Put that aside. Suppose it didn't say infection at all, but it says you have to look after the health and safety of your patients. Does that include infection prevention?
It may very well include infection prevention. I guess all I'm saying is that in this case, Your Honor, where there is express language that talks about that, Congress knows how to do that.
Hypothetical that it wasn't there.
Regulate with such specificity.
Your view is what you're saying is they don't have authority under this. Is that in response to Justice Kagan?
Your Honor,
they can't say wash your hands. Can they say if there's a diphtheria we don't want anybody with diphtheria walking into the hospital because everybody will get it? You're saying they can't say that. Is that right?
Your Honor, there are various measures.
Are you saying that or not? Take the example that Justice Kagan gave of the washing hands or sterilizing instruments, or the one I just gave you of diphtheria. Can they say it or not?
Yes, they can regulate.
All right, if they can say that, then why can't they say the same breath, and by the way, we don't want you walking in here in crowds that will spread COVID, and this is how you stop it. Why can they say the one and not the other?
Because taking off gloves and masks, a vaccine cannot...
I didn't say that. I said diphtheria.
Your Honor, the Secretary certainly has authority to implement all kinds of infection control measures at these facilities. No, I'm not disputing that, Your Honor.
Well, all the Secretary is doing here is to say to providers, you know what, like basically the one thing you can't do is to kill your patients. So you have to get vaccinated so that you're not transmitting the disease that can kill elderly Medicare patients, that can kill. If you're vaccinated, you can still transmit the disease. I mean, that seems like a pretty basic infection prevention measure. You can't be the carrier of disease.
You can still spread it.
But Your Honor, here we're dealing specifically with a vaccine requirement that, again, has historically been in the state's province. And if Congress wants to give that authority to CMS, the federal agency here, it has to do so in exceedingly clear language.
All right, what do I do with this if you want my real? Perhaps you can tell me I'm way off base, and I don't mind if you do. But I mean, here we are, asked for a stay. Okay?
Mm-hmm.
And in the one case, either this will go ahead or it won't. In the case earlier, it'll go ahead or it won't. And to what extent can we take account of what I think would be relevant with stays or not stays or how we act in the interim and da-da-da-da-da. Okay? That there are 750,000 people got this yesterday, that the hospitals are full to overflowing, that there is a problem worse than diphtheria, that people all over the world are getting this and they are here too, and they're dying. That's what we're trying to ask you. Or they're filling up hospital beds and others are dying because they can't get in. Okay? Now, public interest, call it something else, call it what you might. But it seems to me, it's hard for me to believe, look, it seems to me that every minute that these things are not in effect, thousands of more people are getting this disease, okay? And we have some discretionary power. And therefore, will you tell me I can't take that into account? To me, that's fairly unbelievable, but I want to hear it.
Your Honor, the public interest is flexible, and you can
By the
take
way,
all
people
that
are
account.
asking
All
which-
I'm saying is
which
the
justice
two
this
statutes,
is.
the provision
That was
the
Breyer.
Secretary has put forward in
Breyer,
this
thank
case,
you.
we don't have
In my
to
mind, I
assume
had
that they have
Jeffrey
met
Tambor because
their
that's who I
burden of
always
showing
think
a
of when I
likelihood
hear
of
his
success,
voice.
that
A
on the
male
merits,
voice is
those
pro-government
were
is
lawful
pretty much on this
exercises of
one.
authority.
100% Breyer,
Even in
sometimes Roberts.
situations where the Secretary desires to prevent
the
the
spread
spread
of
of
sounds like
COVID,
an
they
old man
cannot
also.
act
You
unlawfully.
can hear the cracking in his
Doubly so
voice.
here again, because this is exactly the kind of requirement that historically has been in the province of the states. And if Congress wants to take that away and give it to CMS or give it to a federal agency, it has to do so in exceedingly clear. Now, I will point out too, in the public interest, Your Honor, doing away with the injunction, as we said so, is going to be devastating to vulnerable patients in rural America, in rural Nebraska. No surgeries. The only anesthesiologist in a rural Nebraska hospital, he is not going to be able to go to work. That means no surgeries. Emergency C-sections.
But I have on that one, I have a question too. I take what you say is correct. All right. I don't know if it is correct, but I'll assume it. Well, if these states, if we act in such a way that over the next 2 weeks or the next week, these rules go ahead as planned, and people do get inoculated because they have to, or now, if the bad thing that you are talking about then occurs, we'll know it. Because what they're saying at the moment on the other side is there is another bad thing, which is the bad thing that I mentioned at the beginning, that hundreds of thousands of people more get this disease. And we know what happens from Massachusetts and in New York, in the old people's homes. Okay?
Yeah, so stop shipping people into the old people's homes.
COVID. And you're saying the one and the agency, the
To be
other,
fair, that
is
wasn't
the more
a
predominant.
Supreme Court decision.
So suppose, if faced with that division, we let it go ahead. And then if you're right, everybody will know it, and we can draw back. That's not perfect for you, but that's at least something, and it helps protect the people who might otherwise get
The
very sick.
vax does not stop transmission
And
of the
unfortunately, Your Honor, it's
disease.
going to, Mr. Chief Justice,
The virus.
Please. Unfortunately, Your Honor, in this case, it's going to devastate local economies. It's going to decimate these local towns that don't draw their pool of applicants from the coast, Your Honor. These are local communities. They run these hospitals. And that is the problem here, Your Honor, is those kind of interests, that perspective was not heard in this context, and that is going to be devastating, Your Honor.
Justice Thomas, anything further? Right? No? Justice Alito? Justice Kagan?
Mr. Rossetti, this rural hospital question, you've presented some declarations that suggest that there would be labor disruptions. The Secretary took that into account specifically. Basically has a different view of the size of the disruptions based on the data that he had. And then in addition to that, said that there are countervailing things. There's countervailing things with respect to the labor force. And the Secretary said some people might come back because they won't have to deal with unvaccinated colleagues. That there will be savings in terms of fewer people out sick and so forth. And then the Secretary has an important job to do, and that's to balance whatever disruptions there are. The Secretary says they're much less than you say they are, but then to balance those disruptions against the safety of the Medicare and Medicaid recipients whom he is statutorily obligated to protect. And you know, it just seems pretty basic to me, as I said, that the first thing that means in the context of this pandemic is that providers can't be carriers of the disease itself. And then in addition, there are other health benefits. You know, people are not showing up to hospitals because they're afraid of getting COVID from staff. And so they're not coming for their mammograms and they're not coming for their colonoscopies and so forth. So he has to balance all those health benefits against what you say are these labor disruptions. And the question is, I mean, you might have a point. I don't know. I don't know very much about the rural market, but, you know, but the secretary, that's his job. Should it be that we decide, you know, as against what the secretary has decided?
You can make a
in
factual
performing his
determination
important
that the
function
vax does
of
not spread
evaluating
transmission of
these,
the virus.
potential disruptions
Supreme
and
Court doesn't like
weighing
doing
those
that.
disruptions against the health benefits that he sees in that rule.
That's generally
Should
not
we
what the
say
Supreme Court is
that
going to be
the
doing in any
disruptions are
instances, for the
more
most part.
greater than the secretary thought?
They've run
and
into
we
more
further
trouble when
would weigh
they've
them
done
differently
factual
against the health benefits of the
determinations.
rule. Is that for courts to decide?
Your Honor, there is a lot there, and I think the simplest way I can answer that directly is, in this case, it's this critical perspective of these tiny communities that, again, he did cite to one example in North Carolina with 35,000, I think it was Novin Health, 35,000 employees, as this is not going to be insignificant to them. But I think that critical perspective of these tiny hospitals that, again, are 100 or less, these numerous facilities that are going to be devastated by this, that sort of relevant factor, that important aspect of the problem, we don't see how the secretary could have properly weighed everything properly when that sort of critical perspective was ignored. And these folks did not have a chance to be heard. And in this case, it's almost as if the secretary put a rock on one side of the scale and a feather on the other. What may work in Detroit and Houston may actually be counterproductive in Memphis, Missouri, or for that matter, in El Dorado, Arkansas. All of those places have different considerations, which is why this historically has been a local and state matter. And the states, again, are free to require it or not require it.
So why is this an issue for the states to require or not require? I mean, this is the federal government paying for services. And why doesn't it have a right as the payer for services to specify what services it wants to pay for? I mean, that's now.
Because they haven't met condition precedent
rules,
of fulfilling the requirements.
I'm having a very hard time understanding how you can say, yes, they could pass a rule that requires people to wear gloves, or they could pass a rule that requires them to isolate individuals who are infected by something. But they can't pass this rule.
Because they haven't met condition precedent of fulfilling all the requirements
if it's clear
for
enough
authorization.
that they can consider safety and health regulations, why is this particular rule subject to us saying no?
Because, Your Honor, this court in Jacobson in various cases has drawn the line at compulsory vaccination being something that the states do. And when Congress...
Well, wait a minute. That's what they do with respect to other issues. But this is with respect to, if you want my money, your facility has to do this.
Sure.
It has to have, it has to serve certain food. It has to serve certain meals a day. It has to give snacks. These are all state issues usually, but under the spending clause, we're the buyer. The federal government says what it wants to spend its money on. This is not an issue of power between the states and federal government. This is an issue of what right does the federal government to dictate what it wants to buy?
Your Honor, it is a vaccine requirement masquerading as a condition of participation. And if Congress intended that, this court has made it very clear that something like compulsory vaccination, even in the spending clause context, which itself demands Congress to speak with a clear voice, it requires...
How much clearer do you need for Congress to say then pass regulations that protect the health and welfare of ill people?
Perhaps the one example I can think of right away, Your Honor, is in E7 of 1395 XE, where Congress acknowledged or spoke with a very clear voice that when it comes to licensing at the state level, that is something that the states do. And that's exactly, I mean, Congress knows how to directly speak to issues that invade into state areas.
And it hasn't done it with health and safety. It has given that right to the commissioner. Thank you, counsel.
Oh, did not allow him to respond.
Justice Kavanaugh?
Interesting.
A couple questions.
But she does have a good point, though.
First, this is an unusual.
The federal government does have a
administrative
very
law
strong
situation
spending
from
power,
my,
and they can
experience,
tie all
because
kinds
the
of strings to
people
that. That's how we have
who are regulated are not
essentially
here
nationwide speed limits.
Because Wickard v. Filburn was the most screwed up decision ever, and it will screw us for generations.
It's a very unusual situation. They, in fact, overwhelmingly appear to support the Secretary's the CMS regulations. So and the government makes something of that. What are we to make of that?
Your Honor, certainly
Gorsuch is right. They're using their money as a sword.
That may have no problem with this. Obviously, there are smaller ones, very small community hospitals that do have a problem with that. But here, the states have their facilities. The
states have a very small percentage of the facilities. Most of the facilities are private-run facilities, right? This picks up.
You think Kagan's going to make the same argument when you talk about Texas abortion? About money? Like, I mean, like,
that's how we usually have. The last case is a good example, obviously. There's a missing element here.
Well, they're not certainly these sort of entities that would be subject to this rule, like small private facilities that receive Medicaid funding, certainly are not plaintiffs per se, but the states do represent the citizens of our constituencies, like these places that run these facilities, these small community hospitals. We speak on their behalves. And all I would say here is we have made value judgments through our policies to not require vaccination because a one-size-fits-all requirement does not help. And that kind of policy judgment, as expressed through our laws, are duly enacted laws that would be applicable both to state-run facilities and private facilities. That is what's being preempted here, Your Honor, by this unlawful mandate. And that's how we're speaking in that capacity here, Your Honor, is the folks whose voices were ignored throughout this entire process and shouldn't have been ignored, especially with these devastating consequences.
And then second, I think you've alluded to this, but how is a vaccine different in kind from your perspective from, say, the requirement to wear gloves or the requirement to wash your hands or the other kinds of requirements? Because I think if you acknowledge that there's authority to require the latter, then you need to explain why the vaccine's different.
I don't think I could say it any better than Chief Judge Sutton did at page 12 of his dissent in the OSHA case, which is masks can come off, gloves can come off. A vaccine requirement, the taking of vaccine is a permanent medical procedure that cannot come off after work is over. That is, there are materially different conditions, materially different procedures at stake. And when you look at the context, for example, in the hospital requirement, 1395 XE, nothing in that statute comes close to authorizing this precise
That was a lab
mandate
question
in this
from
case,
Kavanaugh,
which
which
is
is a
going to
really
have
good
devastating
sign.
consequences for vast swaths of this country, Your Honor.
Thank you very much.
Justice Barrett?
Questions?
Thank you, counsel. General Murrell, are you still on the line?
I am, Mr. Chief Justice.
You may proceed.
Thank you, Mr. Chief Justice, and may it please the court. This case is not about whether vaccines are effective, useful, or a good idea. It's about whether this federal executive branch agency has the power to force millions of people working for or with a Medicare or Medicaid provider to undergo an invasive, irrevocable, forced medical treatment, a COVID shot. It's a bureaucratic power move that is unprecedented. If it can do that, the question still remains as to whether it properly exercised that power here. The district court answered no to both questions at the preliminary injunction stage, and the court below supported its ruling with a number of well-reasoned conclusions. Now, without even addressing all the underlying basis for the ruling, the government asked this court to jump ahead of the Fifth Circuit and dissolve the injunction, irrevocably changing the status quo in a way that will effectively give the federal government all the relief it seeks. This will create chaos in state provider networks, limit access to care for the poor and needy, and eviscerate informed consent for millions of people. The court should reject the government's request and maintain the status quo because the district court's holdings were correct on all counts. I'm happy to take questions or speak to some of the questions that have already been asked by the court.
Just briefly, counsel, I'd like you to address whether or not, or at least to what extent, this rule preempts rules of your state.
Justice Thomas, it does preempt rules of some of the states in our coalition. I don't know that it preempts rules in every state, but it affects Alabama, Louisiana, and Montana in different ways, different laws.
Could you address, as I asked earlier, the parens patriae standing? I think that's going to be an important matter, and I'd like you to address it.
So I think we have parens patriae standing to protect the interests of our citizens, but that is not the sole basis on which we appear in these cases. And there's been, some questions about Medicare and Medicaid. I think the government has conflated those two programs in an enormous way, because just in Louisiana alone, I can tell you that 41% of our budget is Medicaid funding. So we have enormous interest in the way these programs operate, and that's one of the reasons why there are express consultation requirements built into the statute.
Thank you.
General, do you agree with the district court's statement that COVID, this is a quote, COVID no longer poses the dire emergency it once did?
Your Honor, I think that is those are shifting sands. Obviously, COVID conditions can change at any given time, and they have.
But what is your other basis for standing?
Our basis for standing is that we are being regulated directly by this rule. We have to implement it, and it affects our provider networks. It directly affects Medicaid funding, and that is a program that is implemented entirely by the state. I don't think I could underestimate enough the impact on the states and their provider networks. That's precisely what the declarations that we submitted, and I think many that were submitted in the Missouri case also go to, is the effect on our ability to actually provide access to care, which is the actual primary goal of this program.
I'd like to touch on the spending clause issue just a bit. It was a broad provision that you agreed to, which authorized the Secretary to impose requirements that the Secretary finds are necessary in the interest of the health and safety of patients. Why did that not give you adequate notice that something like this could be enacted?
I don't think that gave us any more notice that could be enacted than, no one even expected COVID. So how could we possibly have expected to have the federal government, through a spending condition imposed upon us years after this program was created, co-opt a quintessential state police power for deciding whether its citizens should be vaccinated or not? That's just not something that we could have reasonably anticipated, given the general broad language that is put into the statute. And again, I don't think that their primary role is to actually provide directly for the health and safety of the people. It is to provide funding to the state to implement these programs, or through Medicare to reimburse for health care to individuals. I would also point just to the secondary aspect of any spending clause argument also turns on the voluntarily and knowingly accepting the terms. And so I think that goes straight to your question, that respecting that limitation is absolutely critical to respecting the balance of the state's sovereignty in this program.
Well, it's how does that determination? It is what the secretary finds, and it's what the secretary finds necessary. So I'm not saying there's not some limit there, but I don't know why a provision addressing an infectious disease of this scope is beyond the secretary's determination that the mandated issue here is necessary.
Well, we've never taken the position that the secretary has no authority to address it in any at all. We're saying that they can't do this, and they've never ever done anything like this, which they acknowledge. And the Solicitor General, in the argument that preceded this one, also pointed and conceded that where there are other textual and structural cues in a statute that may be inconsistent with the agency's jurisdiction, that you should be looking at that in terms of the discretion that you give, and whether, when you evaluate whether this is a question or an issue that falls within the general discretion and scope that was granted earlier by Congress. And here there are multiple cues that conflict directly with the broad scope and grant of authority that they're claiming here.
Do you think we need to find that you have parents patriae standing in order to take into account the interests of employees within your state who do not want to be vaccinated? Is that a standing question, or is it a question that can be taken into account in the context of determining what the statute means and whether it satisfies whatever requirements there may be under the spending clause?
I think it's both. I mean, I certainly believe that you can take it into account as part of our standing. We have independent grounds for standing. When you get past that question, I think it also relates to the question of whether it's actually controlling the tenure of employees. I think it directly conflicts with that. I mean, Justice Alito, there's really no question, I think, in our mind that this was a pretext, that the entire, as the Chief Justice alluded to, that this was a workaround. This was an intent, the government intended to tether all of these restrictions together, all of these mandates together to vaccinate as much of the American public as they could touch. And in this particular rule at the Federal Register 61607, the government even acknowledged that the most important inducement here was the fear of job loss. This is targeted at people. It's not targeted at She's way more effective
and they've
than
never
the
done
prior
anything
attorney.
like this before, precisely because there are structural prohibitions against it in the statute. And where we are in this procedure is extraordinary. They want you to dissolve an injunction, parts of which have not even been contested, so that they can upend the status quo, which will disturb enormously our provider network.
Well, all that's true, but I'd like to get your response. I mean, there's some truth to what you say, but I'd like to get your response to what I asked previously twice, really. We sit in both these cases something as the inheritor of a court of equity. And we do that particularly in respect to stays, whether you call them administrative or not. That may be both sides, and in the other case, that's why I say the side in each case that is predicting harm if the agency rule goes into effect. And the other side predicts serious harm if the agency rule does not go into effect. And as you heard in the OSHA case at the last minute, On the one hand, if they have to start complying with this, they have to get plans and the employers are hurt. On the other hand, if they don't start to get those plans ready, looks like a lot of people will get sick and take up hospital beds or worse. So in weighing those equities, why don't we have to take and put quite a lot of weight on avoiding even by a minute or a second? Because if you divide 750,000,
this is where you have to hit on the transmission.
You get a lot of people.
Wait for it. Grave danger.
And why do we not have to take those things into account, see how the government would balance them, see if that is reasonable, and be very wary at the least of interfering with rules that will, in fact, save people's lives or hospital beds or from getting the disease. You see what I am saying? I'm asking, I'm putting a burden on you to say, yeah, that's what I am.
I do. I understand the question.
Yeah.
I think, first of all, these aren't just plans. Here, this rule is different. There's no test and mask exception. This is a vaccinate, and it's a short shot clock. And so they do not have a choice. They have to be fired or they cannot be hired. And so it handcuffs our providers in a way that is extraordinary and immediate. And that the status quo right now is that they still comply with all the other rules of Medicaid and Medicare, which means they have infectious disease control measures in place. They are doing the very best job that they can. They need all the boots on the ground that they can get. And this rule will actually change that. It will immediately change that. So I think it is extraordinarily different. That's and Justice it also Breyer. comes up in a different context. It comes up in the context of a preliminary injunction, multiple injunctions, but specifically in ours, where they did not even contest certain aspects of it. So they present to you a request for a stay that does not even contest certain aspects of an injunction that they want you to overturn.
Thank you. Thank you.
Counsel, I'm having a very hard time.
Keeps having hard times.
Trying to do this state power argument with respect to a standing clause program that doesn't affect the states directly, except as proprietors. Because as proprietor of state-run facilities, those are the ones that are affected by this rule. The private facilities are, and as one of my colleagues noted, Justice Kavanaugh, we don't have many amici of them complaining. But putting that aside, I am having a hard time understanding how and why a rule like this is so substantially different than the volumes of rules that CMS has with respect to so many issues involving health and welfare. They tell you how high the bed has to be. They tell you how close hand sanitizers have to be. This is before COVID.
How does she not realize that taking a shot is
so
dramatically
many different rules that one could
brand
arguably
new
say belonged within the state's rights that give me a working principle that says to the federal agency charged with the health and safety of patients, who believes that the only way to protect
I
these
think that's her
vulnerable
audio, not
patients
ours, right?
is by this one tactic.
This is
by
a
this
justice
one
who has
step.
stood up for her body,
Why
her
that
right
should
for the
tie
last
their hands.
20 years. And now she's like, she's not
You may
understanding
argue
why vaccines are
otherwise, that
different
the
from
other
gloves.
ways of doing it are effective, but they've decided in this particular context, with the vulnerability of these particular populations, that the other steps are inadequate.
Your Honor, there's two aspects to your question, and I'd like to speak to both of them. One is the issue of whether we're just proprietors. We are not just proprietors. And I think the court effectively discussed that in NFIB versus Sebelius. Medicaid is an enormous program where states are contracted with the federal government, not providers. The providers are contracted with the states. So it is important, I think, to keep that distinction between these two programs. But to your question about the dividing line, the dividing line here is precisely why we are in a major questions doctrine land, because they have never done this for at least since the Jacobson case. And before that, predominantly, this has been a question protecting the health and safety of individuals, and exercising this kind of power to force the individual to submit to a medical treatment has never, ever been something that has been authorized by Congress or done by an agency on an emergency basis.
Counsel, I don't mean to interrupt you, but we've never had a situation like this one before. It's unprecedented.
But I don't think in this case that justifies them co-opting a quintessential state police power. In fact, the opposite is true. It only points up the need to evaluate this in the larger context of whether Congress didn't do this, by the way. The Congress, just as recently as last summer, changed some of the discrete statutes specifically related to skilled nursing and nursing homes and authorized certain measures for strike teams to augment staff in those facilities due to COVID outbreaks, but they didn't authorize vaccines. So for staff, I think there are cues. There are cues in the statute. There are cues in the history and structure and the precedents of this court that support waiting and maintaining the status quo, as the district court below did and the Fifth Circuit did.
Justice Thomas, anything further? Justice Breyer? Justice Alito? Anything further, Justice Sotomayor?
I just want to say the Sixth Circuit didn't, correct?
The Sixth Circuit in the OSHA case,
I'm sorry, I
operated differently.
Yes.
Yes.
Justice Kagan? Justice Gorsuch? Kavanaugh? Justice Barrett? Okay. Thank you, counsel. Rebuttal, Mr. Fletcher?
Thank you, Mr. Chief Justice. Just 3 quick points. I'd like to start with the interpretation of the statutes before you that the other side is offering, because I don't hear them to contest that the Secretary's authority to set conditions for participating in the federal Medicare and Medicaid programs includes the authority to protect patient health and safety, even in the statutes that don't include that language. I don't hear them to be disputing that the Secretary can adopt infection control mechanisms or require people to wear gloves or do other things of that nature. Instead, their submission seems to be that vaccines are different. And I think the problem with that is that they haven't really given you a basis to ground that in the statute. The first thing that they've said is vaccination is typically the prerogative of the states. And of course, that's true in some sense, but we're talking here about a federal spending program. And the regulation of medicine is typically the prerogative of the states. Usually it's the states who require hospitals to make sure their employees wear gloves, or they follow the fire code, or they have sprinklers, things like that. But no one disputes that Congress has given the Secretary the authority to make sure that providers who are providing care under the aegis of the federal Medicare and Medicaid program live up to standards set by the Secretary. That's what the Secretary has done here. The other thing that I've heard them say about why vaccines are different is that you can't take them off, that vaccines are somehow different than gloves or other safety measures, and so some special specific authorization ought to be required. And I just don't think that can be squared with the context of the healthcare industry. Vaccination requirements are common throughout our society. They're particularly common for healthcare workers. They've been adopted voluntarily by providers around the country. You have virtually the uniform view of the medical community telling you that this is the best way to protect patient health and safety. If anything, I think it would be bizarre to say that the Secretary's authority to protect the health and safety of Medicare and Medicaid patients does not include the authority to adopt a measure that you see other regulators adopting, the medical community urging, and other providers adopting voluntarily. The whole point of the statute is to let the Secretary make sure that the standards of care for Medicare and Medicaid patients meet best practices, and that's what he's done here. The second point I want to make, Justice Barrett, goes back to the colloquy that you and I had earlier about some of the different statutes. I hope we persuaded you that we're right about all of them, but in case we have not, I just want to make the case that it actually is worth the candle in this stay posture to go provision by provision. So as we explained, 97% of the employees affected by this regulation are covered by statutes that include the express health and safety language. Even if you just narrow it down beyond that, three categories, the largest three categories of providers, hospitals, home health agencies, and long-term care facilities account for more than 90% of the covered workers. This is shown at the table at page 61,603. All of those provisions have express health and safety language of the sort that we've been discussing, and two of them, long-term care facilities or nursing homes and home health providers, actually include the extra provisions that we cite at page 6 of our reply that says the Secretary has not just the authority to ensure health and safety, but also the duty to do so. And I think at an absolute minimum, it's worth letting the rule go into effect as to them. And finally, Justice Breyer, I want to come back to a point that you've raised a few times about the equities because we are here on a stay. And I think a couple of observations to make about the equities. The first is a point that Justice Kavanaugh raised. You don't have providers before you here. You don't have workers before you here. Instead, providers and workers overwhelmingly support the vaccination requirement. Instead, you have before you states who do operate some facilities covered by the rule, but only a tiny fraction of them. The second thing I'd say is that even as to the providers and the workers who are covered by the regulation, some of my friends' presentation has suggested that if the stays are lifted, or if the preliminary injunctions are stayed and the rule goes into effect, that means that tomorrow people are going to be out of a job. And that is not true. The Secretary has put out guidance after the Fifth Circuit narrowed the previously nationwide injunction to cover only the plaintiff states here, put out guidance giving regulated entities 30 days to come into compliance as to the first shot, 60 days to come into the compliance as to the second shot, and making clear that even if a regulated entity has not met full compliance by that 60-day deadline, if the entity is at 90% compliance and has a plan to come into full compliance within 30 days, the Secretary won't take enforcement action. Even if that isn't met, even if at the end of 90 days there's still not full compliance, the Secretary has always exercised enforcement discretion before terminating a provider from the program. And one of the things the Secretary has considered is access to care issues of the sort that the other side has raised. So there are ways to address some of the problems that my friends have relied on, even if the rule goes into effect. On the other side of the ledger, and this is where I'll close, if the preliminary injunctions remain stayed, then we know what the consequence is. We know that this urgently needed measure is not going to be in effect to protect Medicare and Medicaid patients in half of the country during a pandemic. And I think the Secretary found, and I don't think anyone seriously disputes, that any delay in the operation of the rule will cost lives and cause unnecessary serious illnesses. We'd ask that the preliminary injunctions be stayed.
Thank you, counsel. The applications are submitted.
That's what they had to be arguing
The
about.
Honorable Court is now adjourned.
They had to be
until
arguing
Monday
that's
next
not
at 10 o'clock.
it's not curing a grave issue. Do you disagree with me, Alita?
What do you mean?
What I'm saying is, I think that they really had to bring up the fact that the transmission, that there's been no evidence provided to establish that being vaccinated is going to have a significant impact on the transmission. If anything, some people argue that the more vaccinated we are, the more there's transmission. So the agenda here that is purportedly trying to be met isn't even being met. So
well, there's a factual dispute on that, because there are, now this is information put out by the CDC, so take it with however much salt you want to take it with. But according to the CDC, if somebody who is fully vaxxed and boosted, they have a 75% chance of not getting COVID currently. That's according to their data. So there's a dispute about that. And anytime there's this very, very nuanced dispute back and forth between the two sides on a particular point like that, the court is not likely to really get deep into the weeds on that kind of an issue. Like the court wants to take things from a much higher level perspective.
No, I understand what you're saying, but they are taking certain they are making certain factual conclusions inherent in their finding. If they find that they're going to overturn the injunctions, that's relying on certain factual. They are essentially making a factual conclusion that this is a serious threat. For example, they're saying this is a grave threat to not force everyone to get vaccinated. So
to say that they're not taking stock of making a factual assessment, I think that's kind of losing the fact that in order to get to a place that we're defending from, you had to make certain factual determinations. So I agree with you that in general, so they're basically accepting certain factual things, and then you're saying, well, and I'm not saying you, but I'm saying is the other side essentially is saying, well, you're not supposed to be making factual conclusions in the Supreme Court.
Yeah.
It seems like it's like we're making factual conclusions up to a certain point that we're able to ask the question, and then saying, well, your answer here is relying on factual conclusions. See what I'm saying? Like, I mean, and I'll point this out to you. You essentially are making a factual conclusion that the government is correct, that by giving everyone a vaccine, that we're going to be reducing transmission. Well, and that is a factual conclusion that's necessary in order to upend this injunction.
And that's the other point that also tends to be correct in these kinds of cases is that the Supreme Court does like to give deference to its agencies for those kind of factual assertions. So, like it or not, the court generally is going to take a look at whatever it is that the agency in question is coming out with, with whatever studies that they've done, or et cetera, and take them as true, because the court is going to say, between you and me, I'm not an expert. You're the one that does this all the time, so you're more likely to be correct. I'm not about to, go against what you agency are telling me is correct. So that's another burden that this kind of a case faces.
I was unaware that the CDC made a determination that it reduces transmission by 75%. Where'd you see that?
I read it on the CDC's website.
It's the same CDC that has cut the requirement to 5 days from 10 days when the Delta CEO asked.
And it's also the same CDC which changes their mind and updates everything every 10 minutes.
I'm completely with you on that point, that the CDC's guidance could
Kim,
be
what's on your radar?
total BS and not necessarily based on science. There's all kinds of possibilities as to what factors are actually informing the guidance that's coming out of there. But I just say that generally speaking, the Supreme Court is not going to get into all of those details, and they're going to say, all right, this is an agency, we're going to give it deference. This is typically what the court has done in the past.
But okay, Barnes was saying this earlier, and do you guys disagree? They weren't arguing law, especially the liberal justices. They were arguing politics over and over and over and over. I mean, it was like just reading the headlines, and they just kept spitting out the same thing. But it's like, is that relevant? And that's the question: are they supposed to determine whatever the health requirements are, or are they supposed to be speaking to the Constitution, whether something is constitutional, yes or no?
Well, they're supposed to be determining. I mean, the question here is whether or not whether or not CMS for this last argument that we're talking about. Previously, it was OSHA, but OSHA and CMS, whether or not they have the authority to issue the rules that they did. I mean, we had the same question coming out of the CDC having to do with the eviction moratorium, and it was the same sort of issue. Do they have the authority? Is it that expansive that they can make a rule and say that rent is a public health issue? In this particular case, we're talking about particularly employment in these different contexts, and so that's really where the court is having to figure this out. Is where is that line? Gorsuch had his questions about that. Where is the line? And then Breyer was asking on the other end, where is the line? So it's going to come down to, first and foremost, it's going to come down to interpreting the actual statute that gives OSHA and CMS their powers from Congress. Because if the statute is not broad enough or specific enough to allow them to do to promulgate these kinds of rules, then this is the kind of thing that would have a stay issued by the court or upheld by the court.
Where do you think they'll fall? Do you think it'll be 6-3 like as hope, or is it?
Yeah, that's what I was just thinking. That's what I was just thinking about. I mean, look, we know 3-3, right? We know it's going to be you know, Kagan, Breyer, Sotomayor versus Thomas and Gorsuch and Alito. And then you're basically down to figuring out where Roberts, Kavanaugh, and Comey are going to fall. And I'm kind of torn about this because we saw with the rent moratorium that they fell against the broad government power. On the other hand, when it came to DACA and what we've seen, that they tend to lean as rhinos tend to lean. Rhinos tend to basically be all about corporatism and basically falling in line with trust in the establishment. And so I think this really can go either way. I'll tell you right now, any of those three, it literally could be 6-3 in either direction or somewhere in between, because I mean, the questions weren't very revealing. Kavanaugh, I think Kavanaugh is leaning towards upholding the injunction and stopping the government. I think that he's probably a fourth based on his questions based on the form of questions that he asked. So it really comes down to whether or not we can find either Roberts or Comey to come along to say that this injunction should be upheld and stop the government.
OSHA seemed to bring a lot more energy out of them than this one. Or did I read something?
I didn't hear the OSHA one.
Yeah, I didn't hear the OSHA ones either, unfortunately.
Well, they spent over almost 2.5 hours on that, and this one a much more reasonable amount of time. And Roberts seemed to be swayed kind of in the middle. So I think they are really peppering it. I wish Barnes was here because he was explaining it really well, how they were catching Roberts on one of his peccadillos. He does not like the Commerce Clause and how much is shoved through it. So when it started to circle around to that, he was kind of like, So Barnes feels that Roberts is torn because he's fine with the mandates. He thinks they're wonderful, but he has problems with them jamming through the Commerce Clause because that's one of his primary things. So that it can fall either way.
Yeah, it's a scary thing.
Well,
it's so frustrating how we can't rely on having actual conservative justices to determine things the way a conservative would. But what are we going to do? By the way, I got a congratulations. I'm sorry, I didn't mean to.
Go ahead.
Yeah. No, I was going to say I think a lot of it's going to come down to their statutory interpretation more than anything. I will admit that I have not read the statutes in question for CMS and for OSHA that they're using as to whether or not you can really argue that these rules fall within the scope of their authorities. So that's I'm probably going to talk about it on another live stream on my channel at some point. May actually talk about the oral arguments. So before that point, I'll definitely be reading the statutes. But yeah.
On that note, what's the congratulations, Joe, or Grandpa Joe?
Well, there you go. Yeah, I had a new grandson yesterday.
Hey, congratulations!
That's my sister's birthday, by the way. Oh, bye.
And then he left.
Yeah,
I think he probably tried to get rid of some other app or something.
Probably.
And then like some notification came up. Well, but in good news, everyone can see Indy now.
Yeah. Oh, hey, Indy. Yeah, Joe, he just said piss off. He doesn't like us anymore.
He's gonna go hang out with his grandson now.
Yeah, it's time to play with the kid.
He actually, my daughter actually is already out of the hospital and is in my house. We're having like a party tonight because it's Jewish custom on the first Sabbath after a boy is born that we make a party for him. So I'm busy running around getting beer and basically prepping for a huge party, which is why I've been running late, and I'm actually got to cut out now. But
I think I'm wrapping it up now anyway. I think Alita is going to fall over any second.
Yeah, I'm fighting jet lag here. I know there have been a lot of comments in the chat about me falling asleep. I'm not asleep yet, but I'm
She's
fighting it.
There. And I'm not Nick, so standing here for 4 hours is definitely tough on me. Joe, this yesterday is my sister's birthday too, so neat.
Oh, right. Awesome. Happy Siege Day. So yeah, I'm very proud to have a Siege grandson.
When he grows up, he won't even know or care. He'll be like, what was that? All right. Well,
Oh
folks,
man, well,
this has been amazing.
congratulations
Thank you.
and all the health, wealth, and well-being to your grandson and to your whole family.
Thank you so much, Alita. I really appreciate it.
Of course.
All right. Great seeing you guys.
All right, thank you. Thank
Okay.
everybody in the
So
audience.
Eric, we're not doing the other stream, right? That's cool.
No, I think we got it covered here.
All right,
So,
all right, fine. Just want to make
please
sure we're
like,
cool.
subscribe, and if you like stuff like this with more coverage, I'm trying to open it up and make it kind of neutral ground where there could be debates or could be whatever. And by it being laid back news, it's not Eric Hunley channel. So there may be streams that I'm not even on the channel, which I'm perfectly okay with. I want you to be kind of more like a network over time.
Right. Cool.
So,
all right.
Thank you very
Sounds
much.
good.
Later, guys.
Sub and
See you, Joe.
talk to you later.